Good morning, Ms. Bauer.
Good morning, Your Honor. I will be filing an appearance in this matter on behalf of Randy Bailey.
All right, I wasn't aware of that, but I don't have any objection to it, but it does, we're already in a confused posture here today. Ms. Bailey and Mr. Millerans, would you join us, please?
Yes, Your Honor, we're present.
All right, Mr. Millerans there as well?
Yes, Your Honor.
Oh, boy. Mr. Millerans? Would you get up and put on a shirt?
Yeah.
Uh,
Yes, Your Honor.
gentlemen,
I'm actually trying to find a shirt right now as we speak, Your Honor. Sorry about that.
This is a trial. Boy, I can tell you have great respect for the process. All right, the title of this case is Golden Pond Estates versus Travis Millerans and Randy Bailey. They wish to terminate their tenancy primarily because of the misconduct of Travis Millerans, who shows up for court without a shirt. Mr. Steve Cromendike is here on behalf of Golden Pond Estates. We've been tussling with this case since early December. Randy Bailey is present, and Meg Bauer is here from legal aid. Theoretically, this matter was set for a trial today on a termination of tenancy. Mr. Millerans and Ms. Bailey wanted a jury trial, and they don't have the wherewithal to conduct a jury trial. They didn't file the information in a timely manner. I didn't set the matter for a jury trial.
Wait, Judge, I'm sorry.
I
Did they not file in a timely manner?
I can't remember. Maybe I'll take a look. Maybe they did. So you're contending there's a jury demand in here?
Yes, my understanding is that they filed a jury demand within the 5 days of the first hearing and paid the jury demand fee or had it waived.
I'm not sure that's accurate, but all right, let's assume for the sake of argument it is. I set this for today. All their witness and exhibit lists were due by January the 9th, which they filed on January 28th.
I don't believe the plaintiff filed a witness or exhibit list in this matter.
No,
He
they
did
didn't
file
either.
exhibits.
So plaintiff filed a motion for summary disposition that the defendant has not had an opportunity to answer, and they amended the complaint that the defendant has not had an opportunity to answer. So if I understand correctly, Ms. Bauer, you'll be representing only Randy Bailey?
Randy Bailey is the listed client in our system. If the court would prefer that I make my appearance on behalf of both defendants, I can do that. And I am primarily motivated to be involved in this case based on the procedural confusion.
Well, one problem is Randy Bailey and Travis Millerans they have conflicting interests. The primary reason they want to evict Ms. Bailey is because of the conduct of Mr. Millerans.
You have articulated my apprehension about appearing on behalf of both defendants.
All right, why don't you go ahead and place your appearance on the record as who you're appearing for.
Thank you, Your Honor. Attorney Meg Bauer, P84816, appearing on behalf of Randy Bailey.
All right.
Your Honor,
Yes,
if I
sir.
may, Meg and I talked for quite a bit yesterday afternoon, Meg, about a potential conditional dismissal here and what terms of that would look like. I have not been able to follow up with you until now about it. You said you were going to talk to your client, which I suppose is just Randy at that point, at this point. But in any event, has there been any progress on that?
Well, I'm glad that Meg is here. These people could use some help. They claimed that they had legal knowledge, which they don't, and that you guys can discuss this matter in a rational manner. And nobody wanted to be here today. I appreciate, Mr. Commandant, you were going to have to drive down here from Holland, and everybody would have to be here. So on short notice, I turned this into a Zoom hearing. Ms. Bauer, do you think there'd be any merit to you either discussing it further with Mr. Commandant or with Ms. Bailey in a breakout room?
I did speak extensively with the tenants last night, and I thought that Attorney Cromendike also needed to speak with his client. So I have a little bit of an understanding of the range of possible settlements based on my conversations. I am hopeful that something is possible.
I've talked to my client, and I believe he's on board.
All right. How about if I put Miss Bailey, I'll put you in the waiting room. Don't go away. Meanwhile, Mr. Millerans can get pants and a shirt. And I'll put the two of you in a breakout room and see if you can get the details of the conditional dismissal. And maybe we can have some good result here today.
And Judge, I made it clear to Ms. Bailey that I was going to articulate this to you, but my presence here is primarily in service to the court. Obviously, I have an ethical obligation and legal duty, but.
Well, I've already said I appreciate your being here, and you all very often help resolve difficult cases, and I do appreciate that. All right, I'm going to put both of you in a breakout room. I'm going to sit here and think deep thoughts for a while, or maybe not so deep thoughts. All right, I'll give you both the first line of the day. You're breaking my heart. You're shaking my confidence daily. All right, you guys think about that.
I know it. I just can't think of the next line now.
Sing it. That'll come to you. I didn't give you the first word. The first word is the title. You're breaking my heart. You're shaking my confidence daily. I'm down on my knees. I'm begging you please to come home. All right, you guys go in the breakout room and I'll think about that.
I'll practice so I can get my Oscar next time.
All right,
Because I
thank
don't
you.
even know what it.
I'll leave it to you guys.
Well, the album is about 55 years old, it's Mr. Cromendike, but you might know it. All right, hopefully they're going to Meg just gave me, or Elaine just gave me the jury demand. I was looking for it in the file. There it is. Was filed on December 5th for Travis Millerans. And they paid the $50 fee.
did operate a motor vehicle with a suspended license in the township of Brownstown on Telegraph near Andrew at 10:46 PM. That is a misdemeanor punishable by up to $500 in fines, 93 days jail. Costs are all of those 2 points. Do you understand that?
Yes,
You also have a no proof of insurance, 0 point civil infraction charge. Do you understand that?
yes,
And did you sign, read, and understand an advice of rights form?
yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
yes.
All right, $500 personal bond. I'll enter a not guilty plea. You still wish to waive your right to a lawyer? You don't have to post any money.
No,
Okay, so I'm going to enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court during the pendency of the case. You cannot violate a law. You must appear in court as directed. I'm entering a plea of denial on the no proof of insurance, plea of not guilty on the suspend. He's going to take to the file to the prosecutor. You go out in the hallway. She'll call you in and you can talk to her then. Okay?
okay, thank you.
Best of luck. Cameron Jamal Cottrell, 25W839-925. Your name, sir? You're charged with failure to pay. It is alleged that you did fail to pay $213. If I find you didn't pay and you could have paid, that is, that your failure to pay was not without your fault. You could be incarcerated 1 day for every $10 owed. You could get 22 days. You get $10 credit for each day served. So if you paid $113, you'd only owe $100. You'd have to serve 10 days then. Do you understand that?
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes,
You have the right to an attorney. If you want one, I'll give you one. Would you like a lawyer? It's the charge you failed to pay $213. How do you plead?
yes,
I'm sorry.
yes.
Did you fail to pay?
Yeah, I feel like.
You have it all now?
No, I just started working, but I have it for next week.
Anybody force you to plead guilty?
No,
Plea is accepted. Where do you work at?
last call,
How much do you make?
800 a week.
You know you can't, you get paid weekly?
Yes,
You know you can't ignore courts like this, right?
yes, I know.
I mean, hang on. I know, but you didn't come and talk to us. You didn't do anything. The ticket's been outstanding since January. All I'm telling you is you're much further ahead if you go talk to the judge before it gets to this point. I'm going to let you pay $50 per week. You can pay more if you want. I'll let you pay $50 per week. You said you're going to get your first check next Friday, true?
Yes.
Starting February the 9th. If you don't have the money, no problem. Call the court. We'll go on Zoom on or before any one of your due dates if you don't have the money, and I'll give you an extension and everything will work out, okay? Just don't ignore me. I don't like that, okay? Best of luck. You're all set. 50 a week. Ashia Lynn Abston, 25T646293. Your name, ma'am? All right, you're charged with failure to pay $232, and you still owe, since this is a no proof of insurance, a clearance fee on that. You're charged with failure to pay $232. If I find you could have paid and didn't, you could.
She does have a balance now of 277. It looks like she has a suspension on there.
No, I know,
Okay.
but that's okay. So you still owe the suspension fee of $45, but this is a show cause for failure to pay $232. So you could get 24 days. Do you understand that? And did you sign, read, and understand the advice of rights? In other words, if you could have paid and didn't, you could be incarcerated 1 day for every $10 owed. Do you understand that? If you plead guilty here, you're giving up all the rights on that advice of rights form, and we're not going to have a hearing. Do you understand that? Do you have the right to a lawyer? Would you like one?
No.
All right. To the charge, you failed to pay $232. How do you plead?
Yep.
You failed to pay?
Yes,
You have it all now?
I do not. I have $40 and I can pay the rest completely on the 6th.
Are you sure?
Yes, because I'm working.
If you don't have the money, I'll be glad to give you an extension. You need more time than the 6th, I'll be glad to do that. You sure you can pay all by the 6th?
Yeah, I have $40.
That's fine. That's fine. You paid 40 now, balance by February 6th. Let's say something happens before February 6th. I don't know, you need work on your heater. Who knows?
Call you with a test.
Go on Zoom. I'll give you an extension. I don't care how many times we have to do it. Just don't ignore me, okay?
So much.
Have a great day. Lacey and Jones, how are you? Who are you here on?
Good morning, Your Honor. I'm here for waste management, your case number ending in 0191.
Have you talked to the prosecutor?
I did, Your Honor.
Okay, as soon as she brings the file in, I will call your case, okay?
Th-
She should be
thank you.
bringing it in momentarily. Janae
Thank you.
Monique Pinkston, 25B147812A. Your name, ma'am? You're charged with failure to pay $900. That is the charge. If you plead guilty, if you're found guilty, you could be incarcerated for 5 days. Do you understand that? Did you sign an advice of rights form here today? You have the yellow advice of rights, John? Or it's a white one? Okay. If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing. Do you understand that? You do have the right to an attorney. If you want one, I will give you one, if you're like a lawyer. To the charge that you failed to pay $900 in fines and costs, how do you plead? Were you ordered to pay $1,295 at the rate of $60 biweekly after your fines and costs were paid on the other file?
Yeah.
Did you make those payments? I didn't ask you that. Did you stay in compliance with the payment plan?
No,
Did I tell you to come and talk to me if you didn't have the money?
yes,
Did you do that? Why not?
I was having trouble finding a way here. I've been struggling with the ride.
You know how to use Zoom?
Yes,
Well, why didn't you Zoom? I told you you could Zoom too. You can't ignore courts like this, man. Do you?
yes,
Good. Then you and I will get along just fine. Anybody forced you to plead guilty here? Plea is accepted. The failure to pay fines and costs of $900. All right. Now, I sentenced you back on April the 9th
yes,
to 16 months probation, meaning that your expiration will be on August the 9th.
Yeah.
Where do you work at?
yes,
Have you done everything else?
yes,
Outpatient treatment,
yes,
victims impact,
yes,
AA?
yes.
You did your,
Do AA, I went straight to the treatment.
okay. Do you have court, did you do court work and community service? All right. Well, tell me how much you make, how many people you're supporting, if any. Do you have children?
Yes.
How many kids? Well, good for you. Boys, girls? All girls.
Seniors,
How old are your kids?
18, 17, and 16.
You married?
No,
How much do you make in your employment?
$20.
So you work 40 hours?
Yes,
You make $800?
yes.
How much can you afford to pay? Do you have any money to pay toward this today?
I don't have anything today, but next week I plan on paying the full 904.
Are you sure? How are you gonna get that?
My job, when I get paid, my check comes out, I'm gonna pay it in full.
Are you sure?
Yes,
I don't need it all next week.
just gotta get it done.
Okay,
I'm complete and everything.
I'm gonna assess costs of $25. I'll go light on you since you're gonna do that. You pay this by February the 9th, okay? Just to give you a few days to get it here. You can go online, you can make your payment with no fees at all if you're paying that in full, okay? So it's $925. Any questions? Otherwise, I'm gonna keep you on probation, subject to all existing terms. Wish you well. Just don't ignore courts again, okay? Be careful out there. I have this lawyer working on waste management. Could you bring the file in?
I will, Your Honor.
Thank you. Stump. Jacob Timothy Stunk, 25F11627. Your name?
Jacob Stump, Your Honor.
Morning to you. Where you been?
Basically with that I missed. I got the date mixed up.
All right, let me go ahead and, arraign you and I'll give you your rights here, okay?
So,
You are charged with a violation of probation. Placed you on probation for 12 months under section 771.1. Not yet.
12 months?
6 months.
Oh, okay, scared.
My mistake,
Yeah.
my mistake. September 4th. And, I have a charge that alleges a variety of different violations. Count one, that you failed to attend your scheduled probation visit on January 9 of 26. That's one charge. Do you understand that charge?
Yes, sir.
Count two alleges that you failed to attend anger management with 4-week follow-up. Do you understand that charge?
Yes, sir.
Hang on. Do you understand the charge?
Yes, sir.
Count three, that you failed to provide proof of completing 1 day of community service by October 31, 25. Do you understand the charge?
Yes, sir.
You plead guilty, or if you're found guilty of any one of those.
Not wrong. Not
Now,
wrong.
listen to me. Let me finish. If you're found guilty of any one of those, you could get 5 days. If you're found guilty of all, you could receive 15 days jail. Do you understand that? Did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer?
Yes, sir. I if you want to give me, I appreciate
I'll
it.
give you a lawyer. I'm entering a not guilty plea. We're gonna get you a lawyer. You'll speak to the lawyer, and as soon as you're done, tell the lawyer that the judge said to bring the file back and come on into the courtroom and I will take care of it. How's that?
All right.
Thank you. Let's go into the defense lawyer probation. Go out in the hallway and my court officer will set you up with the defense lawyer. All right?
Thank you.
Thank you. People against. Waste Management, file 26B150191. Good morning, your appearance, counsel?
Good morning, Your Honor. Carrie Barrett on behalf of Waste Management.
All right. Good morning, Ms. Barrett. I don't think I've had you in here before, have I?
I haven't. No, it's usually Sean Powers, but he's on vacation. So
Good for him. I hope he's
filling
somewhere
in for him.
warm.
He is. He and his wife went to Florida.
Nice. I was just there. It was cold for a few days, but
Yeah. Where'd you go?
I went to Naples, Twin Eagles, a golf community with my good
Yeah.
buddy Ron and Nancy Muir, and met, and they're good friends, Suzanne. They got a whole bunch of good people there. So
Nice.
I was there for a few days, so it was nice. Didn't want to come back. Anyway, I won't keep you. You're going to plead the overweight with agreed upon fines and costs of $1,700. True?
Correct, Your Honor. We'll plead responsible.
All right. To that charge again, responsible or not responsible?
Responsible, Your
Plea is
Honor.
accepted. $1,700 fines and costs paid by February the 27th. Okay.
That's great, Your Honor. I appreciate your
Have a great
consideration.
day. Thank you very
Thanks, you
much.
too. Nice
Bye
to
now.
meet you. Bye-bye.
You too. All right. Are those sentences, do you know, with retained lawyers, defendants?
No. No one's checked in with me at the sentencing, so
Do I have any retained lawyers on those?
Gabe,
Who?
he's retained on the sentencing.
All right, bring them the file. Tell them,
Period.
we'll bring them the file. Tell them that and say, if they're not here in 20 minutes, we're issuing a bench warrant. I've had it with these people showing up whenever they feel like. Those were scheduled for 8:30, I believe, right?
At least one of them.
The other one's scheduled for 9:45.
Yeah.
All right. Can I see the docket? Are all the defense lawyers here? Is Shamarian, do I have anybody out on Zoom, Heather? Or is everybody just getting into the habit of showing up whenever they feel like?
Nobody
these
is out on Zoom, Judge.
All right, give me
The-
Shamarian.
The
What's
only
that?
person I have was Officer Paul for the priority waste, but he's in a breakout room with Caitlin.
Okay.
Yeah, you don't need to hold on to this. I can just write it up as a no-show.
Let's do it now. And if Shamarian Christopher is not here, I'm gonna issue a bench warrant for her arrest. It's 50 minutes late. And then I'm gonna do the same thing with, well, the other sentencing, I guess, isn't scheduled till 9:45. She didn't check in.
And I just checked with the front too, so they have not checked in, Judge.
Shamarian Christopher is not?
Correct.
Okay, I just wanted to make sure. Just yell the name Shamarian Christopher out there, will you, Will? If she's not here, I'm issuing a warrant. Thanks. Yeah,
That's all you need, Judge?
yep, thanks.
Okay.
Thanks. People against Shamarian Christopher. Shamarian Dwayne Christopher, 25B149709A. And before I issue this warrant, we notified the victim. Is anybody here? Do you know? I just want to double check. Chahal Brothers Transport out of British Columbia, I believe. And Pawan Singh, these were the victims out of Hamilton, Ontario. So Singh, S-I-N-G-H, or Chahal Brothers Transport. Either one of them appear?
I have nobody on Zoom, Judge.
Perfect. Okay, good enough. Defendant failed to appear for sentencing. Victims failed to appear. Warrant to issue. Case was scheduled for 8:30. It is now 9:21. Warrant to issue. Bond to be forfeited 3,500, 10% on the A file. And we will go from there. And on the B file, I will I'm going to go ahead and give fines and costs of 195. Yeah, fines costs of 195. Defendant failed to appear for sentence. That's a civil infraction, so that would be the judgment amount. Off the record. What's your name, sir? I'm sorry?
National Electric.
Is that a criminal case, sir?
Oh, no, I'm here. I don't believe it. I just got a piece of paper saying to get here today at 9:15.
Oh, National Electric, arraignment pretrial. Okay. Does the prosecutor have that file, John? Or do we?
Sure thing.
You know what? I think National Electric LLC 26B82503. Come on up to the podium, sir.
There is no All right, we are back on the record and back on the live feed in the matter of Golden Pond Estates versus Travis Millerans and all other occupants, which include Randy Bailey. Miss Bailey and Mr. Millerans are here. I assume you put a shirt on since we last saw him. Meg Bauer and Steve Kromendijk have been discussing this matter at some length in a breakout room. And Ms. Bauer, I'll defer to you. What's our current status?
Thank you, Your Honor. Attorney Kromendijk and I have had extensive conversations, a conversation about the range of settlement terms. And although we're close, we've got a few details to massage out still. So for that reason, we'd like to ask the court to schedule us to keep us on track, that perhaps we have the court schedule a pretrial, perhaps a deadline for witnesses and exhibits in a couple of weeks. And we were discussing that ideally the week of February 16th, but obviously depending on the court schedule, with the hope that we'll have a settlement that we can have executed and entered at that hearing, but understanding that that's a turning point to keep us on track.
All right, the clerk did bring in the jury demand. It was in the file. I couldn't find it. It was filed within 5 days of the original hearing on December 5th, and the defendant did pay the $50 jury demand fee. So theoretically, this case would be set for jury trial. There are a couple concerns. I don't think there's currently any valid lease in effect. Do you agree with that, Mr. Kromendijk?
I do.
We've been tussling with this, as I said, since December. Will be December, January, and February. There is no escrow order in place. Is a plaintiff requesting one?
We're not, and frankly, there hasn't been an issue with payment of rent.
And Ms. Bailey, we've discussed the portal being unlocked.
All right.
Thank you.
All right. Let's look at February 16th.
And
that might be President's Day.
And my thoughts were that we don't bog your schedule down with a day blocked out for a trial at this point. Because if it's not necessary, we keep the date open for the court.
February 16th is a holiday. I normally try to be gone during that holiday, but I'm not.
I think.
Let's look at February 13th.
I think
13th, I'm going to be out of town.
All right.
Steve, are you okay with the 20th? I know that's typically the landlord tenant days are Mondays and Fridays.
20th would work.
I have an important appointment at Sunset Key, which used to be called Beer Can Island, on February the 20th.
My apologies, Judge. I wouldn't want to interfere with that.
I've got to go buggy unless I get out of here again. What is this? That takes us all the way, I apologize, to February 27th. Friday,
27th
February
would work for me.
All right. At 11 o'clock. It's going to be problematic because I'm missing so many Mondays and Fridays in February. The days are going to be kind of dense, but I think I may be able to put some things in the afternoon of that day. So we'll block out 1 hour on Friday, February 27th at 11 to 12 for status conference. If the matter is resolved before that time, you certainly can file a conditional order of dismissal at any time. Miss Bailey, Miss Bauer has filed a verbal appearance, and she'll file a written appearance on your behalf, and you've been discussing things at length. Mr. Millerans, my advice to you is that you continue to keep things on a low profile. There are a number of things that you are alleged to have done, which is why they want to terminate your tenancy. So
Your
my
Honor.
advice,
Don't interrupt.
well, I don't, we haven't got to that issue. They're accusations. So just don't bring up any more accusations. I don't want any more disturbance or discord out there. That'll just make their case easier. All right. Parties did work at resolution, weren't unable to get there.
Well, that's a question.
I'm allowed to speak.
Yes.
It's actually for Mr. Cromendike. Because I was locked out, of the portal, can the $50 late fee that was put there for January's rent be removed? Because Casey did
Well,
ask
we
for
can
the
discuss that later. Right now, you can't pay your rent. In a termination of tenancy case, they can't accept your rent.
But
So
they're
they can't say
asking
we
We're
don't
not gonna-
accept your rent, then give you a late fee. So you can discuss that with Ms. Bauer.
Yeah.
But certainly keep stockpiling the money if there's an issue regarding rent.
Judge, we're not going to raise a Park Forest waiver argument at this point, but we'd much prefer to have the rent paid.
All right, then you guys can discuss that. Defendant will allow rent to be paid. It's interesting. It makes sense. What happens is people don't pay the rent and they don't set the money aside. They spend it on car insurance or groceries or lottery tickets or whatever. And then when it comes time to pay the rent, the money's gone. So there is certainly logic in continuing to pay the rent. We don't have an escrow order. And that way the rent will not be an issue. So I guess I can accept that. All right, this matter's continued all the way till Friday, February 27th, which is about a month from now, at 11 o'clock. If the matter is resolved, that's fine. If it isn't resolved, we'll set a jury trial date at that time. All right, we will have a finalization of any witness and exhibit list by that time. Mr. Cromendike, any further?
Nothing.
All right, I'll see you guys in February or sooner if you do work out a resolution.
Ms. Bailey, I
All
will
right,
give you a
Miss
call.
Bailey. My advice
Your
is you
Honor.
stay in contact with your lawyer.
Yes, thank you, Your Honor. Thank you, Meg, and thank you,
All right.
Mr. Cromendike.
All right, Mr. Millerant, you as well. Thank you both.
Yep.
Thank you,
Thank
Judge,
you.
for the time. Steve?
All right, well, we inched a little closer to the finish line. I'm hopeful they can come up with a solution. We'll stop our live feed. We'll be back at 10 for a sentence.
See, raise your right hand. Do you solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please.
Erica Hogan. Erica is Brika, last name Hogan. Hogan.
Main Court. Thank you. Erica, where do you live?
At 480 West Clark.
Okay, and is now back on June 14th, 2025. Do you remember that day?
Yeah.
And on that day, did you live at 4800 Clark Road, apartment 313?
Yeah.
Or excuse me, 30, yeah, 313.
Yes, it's apartment 313.
Okay. Thank you. Now, at about 9 p.m., did something happen that caused the police to get called?
Yes.
Okay. Take us through what you were doing prior to the police getting called.
Prior to the police conversation, I was moving in.
Okay. And when you say you're moving in, was this a new apartment to you?
Yes.
Okay. So what were you all doing? What were you all moving in?
Boxes.
Okay. And about how long was that taking you that day? Now, was your apartment is that in Ann Arbor, Michigan?
Yes, it's, yeah.
And is that in Washtenaw County, Michigan?
Yes.
All right. Oh, it's not in Ann Arbor. I'm sorry.
Sure.
Pittsfield Township, correct?
Yeah, it's more than it's Ann Arbor.
Okay. We don't have much of Park Road, but I'm sure we probably are. But it's recognize that it's in Washtenaw County in 14A district. So thank you. Now, so you'd been moving in, and around 9 p.m. or so, did something happen to interrupt your moving in?
Yes.
What happened?
There was an altercation.
What do you mean an altercation?
I was walking down the third floor hallway to my unit to take things in. I was approached by someone, and basically what happened was I guess he's upset about the noise that was going on with us moving in. And he made some pretty obscene statements to me, my mother, my daughter, and one of her friends.
Is that person in the courtroom today?
Yes.
Can you point him out and describe what he's wearing? Can you describe what he's wearing, please?
A tan 3/4 zip sweater.
Okay. And do you know who that person is? Do you know their name?
I just know that.
Okay. Ask the record to reflect the identification of the defendant. That objection, record, so we're fine. Thank you. Now, you said that there was some words that were stated by him. What did he say to you?
The statement that he made was, you know, you guys are playing around and ass grabbing in the hall.
And when this happened, whereabouts in the hallway were you?
I was about face to my door. So between the elevator and my apartment unit, I was about halfway there. Yeah.
And now he lives in apartment 306?
Correct.
And is that also between the elevator and your apartment?
That apartment is actually right, almost kind of like directly across from the elevator.
Okay. But would you have had to go past 306 to get to your apartment?
Yes, like I would have, as I'm stepping off the elevator, you know, you're right there.
Okay. When he approached you and said that you guys were ass grabbing in the hallway, where in line was your mother and your daughter and her boyfriend?
As we were walking down the hallway, I was in the front. I want to say my mother was behind me, then it was my daughter and her friend.
Okay. Now, when you are going down the hallway, who did he confront first?
It was kind of like he generalized the statement to all of us. You know, and it kind of didn't get directed towards me until we got closer to the door.
Okay. Did he get in front of you as you were walking down the hallway, or how did it, what happened?
He ended up kind of like on the side of me as we were going down the hallway.
Do you know if he followed everyone and caught up to you who was first in line?
That's what happened.
Okay, okay. Now, when he got up, even with you, did he say anything else?
He was pretty much just making statements about how loud we were being. We should have picked a better time to move in. And it just that kind of was the gist of what he was saying.
Okay. Why did you move in at that time?
That was the time I was able to.
Okay. Was that based on your schedule?
Right.
And your help's schedule?
Exactly.
Also, your work schedule?
Yes.
All right. Now, were these relatively new apartments at that time?
This is a new apartment complex. Yes.
Okay. And the apartment complex had been there about a month in total? Give or take?
Yes.
Okay. All right. Now, as you approach, did you approach your apartment door?
Yes, I did.
Okay, what happens at that point?
As we approached the apartment door, I kind of, just thought he was gonna go away. So when we went into the unit, he stopped the door with his foot and proceeded to like shove past me, push past me to gain entry into the apartment at that point.
Who opened the apartment door initially? And did you go into the apartment first, or did you let other people go in?
I went in, but the way that the doors are set up, they're slow closing doors. So you don't close the door behind you, it kind of closes on its own. So as I walked in, everybody else kind of walked in behind me. And before the door closed, that's when he, kind of like stopped the door. And when he stopped the door with his foot, that's when I turned around and I was at the door and he pushed past me to try to come in.
Okay. Now, when you say he stopped the door with his foot, did you see where his foot was?
Yeah, it was, so when the door is closing, it's kind of like the silver, threshold of the door area. He put his foot right there to stop the door from closing.
And was it towards the side of the door where the handle is, or the side of the door where the hinges are?
Where the handle is.
All right. And then you said that, so where were you at that point when he put his foot to stop the door being
I
closed?
was right in front.
Okay. When you say in front of the door, on the outside of your apartment or the inside of your apartment? Okay. And when you say, now describe what you mean by he pushed past you.
So when he put his foot in the door, I still tried to close the door, and he had his forearm out like this, and he did like this and kind of like stepped into the.
Okay, now you just made a motion with your forearm.
Yes.
You have to kind of describe for that because we can't, we're recording things and so can you describe the arm motion that you were just making or the position you put your arm in?
Yeah, so he extended his forearm out towards me, and when it kind of pushed into my chest, that's when he stepped into the apartment.
Okay. Now, when so he had put his foot in a place that would prevent the door from closing completely.
Correct.
Did you open the door back up, or did he push the door open?
No, that's the thing. Before the door could completely close, he stopped it with his foot.
Okay.
And when he stepped into the apartment, that's when he pushed me with his forearm.
Okay. And did you see what was pushing the door, or was anything pushing the door? Better question.
No, I mean, his foot had the door open,
Okay.
and once he stopped the door with his foot, he could essentially put his arm in the door.
Okay, inside your apartment?
Correct.
All right. Now, using your, and then, so could you see if he held the door open with his arm? Did he use his arm on the door at all?
I don't know where his right arm was.
Okay.
I just could see the left arm that he used. and the foot they used to stop the door.
I see. Now, did his left arm make it inside of the threshold of your apartment?
Yes.
How much are using using your hands, and then we'll kind of approximate that. How much was your door still open when he stopped it?
When he caught it with his foot, if I had to gauge about how much the door was still open when he caught it with his foot, it was probably about like this much space before the door closed.
Okay. And that's, are you any good with the measurement?
12 to 15 inches, I said.
Okay. Thank you, Judge. And did the door open more in this incident?
It prevented the door from closing.
Sure.
So, I don't want to make the assumption, but the only thing I can assume is that his right hand had to have been on the door.
Fair enough. And we don't want you to guess. Okay. But when he used his left hand, did he have to reach around the door to get to you?
No, like it's kind of almost when he put his arm out and pushed me through the door, the door opened more at that point.
Okay.
So
and
it just stay at that same angle the whole time.
And correct me if I'm wrong, but you're gesturing in a way where his left arm is pushing on you.
Correct.
Okay, and that's about shoulder height or so on you?
Yes.
Okay. And at that point, let me back up. Did you invite him in your apartment?
I did not.
Did you say, hey, come on in, we'll talk about this?
No.
Before he stopped the door closing, had he said anything else to you about the noise?
He was just still talking, repeating the same thing, like, you guys are playing around in the hallway, the ass grabbing, and, you should have picked a better time to move in, and all these kind of statements. And it was more so me walking away, going into the unit, like trying to ignore the conversation.
Once the door is held open, does the defendant say anything to you?
The same thing. He was just saying the same thing, and it kind of turned into at that point of, can you, get away from my door?
Okay. Now, did you tell him that?
Yes.
All right. Once he holds the door open, what did you tell him?
Can you get away from my door?
Okay. Sorry.
Can you just leave?
Did he respond to that?
He continued to talk and stand there.
Did you do anything else?
I did not.
Did you ever try to push the door closed?
My daughter.
Okay. And did you?
How old is your daughter?
17.
17.
Yes.
Thank you.
What did it take to get the door closed? Or actually, maybe back up. Were you eventually able to close the door?
Yeah, my daughter actually closed it.
Okay. And other than saying, I think you said that please back up or something. Did you tell the defendant anything else?
I told her that I was going to call the police.
All right. Did he say anything to you at that point?
Just still repeating the same thing. I guess he was upset about the noise.
Okay. How far into your apartment did he get when he tried to push his way in?
About like the whole left side of his body.
Okay. But was the right side of his body still, if we use sort of the threshold of your door as an imaginary force field, half of his body's inside, half of his body's outside?
Correct, yeah, because he came in at an angle because of how the door still kind of was at that point. And when he made the motion to push past me, he kind of stepped with his left side, so.
So it's not like the door ever swung all the way open.
No,
And you didn't pull the door open as he was standing there preventing it from closing.
can you repeat that?
You didn't open the door as he was standing there preventing it from closing.
No,
Did you want to continue the conversation with him?
no,
Why is that?
because I don't know him and I didn't know what he was gonna try to do. And at that point, like I said, my daughter was home, her friend was there and my mom. So I was trying to avoid the confrontation.
If I can have 1 second, Judge. And now, thank you. I don't have any other questions.
Before you begin, Cross, what time was this happening, ma'am? You said 9 PM was when you're moving in, but when this happened,
I can't remember the exact time I called the police department. But I called them right after the incident took place.
okay, all right. And just also for clarification, you said your mother, your daughter, and who else was with you?
My daughter's friend,
Male or female?
male.
Cross-examination.
Thank you, Your Honor. Good morning, Ms. Hogan. Where do you work?
At Washington Community College,
Okay. How long have you been there?
a little over here.
At any point, were you trying to get hired by the community corrections for the jail here?
Yes.
What is the relevance?
They had quite a extended talk while she was talking to the police about her plans to become a police officer. And she stated that they had encouraged her where she already was to become a police officer. And one of the police officers responding said, "We're hiring." And it goes to show bias of both the witness.
Understood. You can go ahead with the questioning. I'll overrule the objection.
So did you at any time indicate that you had applied to be a corrections officer?
Yes, ma'am.
Okay. So I want to go back. The incident you're talking about here happened on June 14th, correct?
Yes,
You live in one unit and your mother lives in another unit on the same floor. Is that correct?
yes.
When did your mother move in?
Objection relevance. Overrule. I'll allow.
A few weeks to a month before.
And do you recall who was helping you move in that time?
Moving for.
To your mother's? Who was home?
It was me, my mother.
What you do?
So this is Officer Blue. He is our comfort and care dog for the department. He is an English cream golden retriever and his whole job is just to love people. So if you're feeling stressed, if you're feeling happy, if you're feeling anything, and you want to pet a dog, that's what he's for. I'm often asked, well, you know, if someone tries to attack you, they'll go after them, right? No. If somebody hides something, he can find it, right? No. But let's be real. Sometimes loving is hard. He has a hard job, right? We've had him since he was 8 weeks old, and he goes out into our community. I'm the community resource officer, so my job is just to do all the outreach and education in the community. So he comes along with me a lot to events, to nursing homes, to schools, court. We're super excited to be invited here today. He's just going to be wandering around. Feel free to pet, love. Somebody was laying on the floor with him earlier. That is not, I wasn't going to call you out. That's not an uncommon response to him. I mean, he gets that all the time, and he will just let it happen. So if you need some love, just feel free to call him over your life.
Thank you, officer.
Thank you for having us.
Yeah, I got to tell the story if you don't mind, Officer Morgan.
Sure, Judge.
So we had a jury trial a few, I guess it was that in December?
Yeah, I think it was.
December, and there was a gentleman that was charged with an assault on 2 police officers. And what had happened was he came into the Springboro City building and he wanted to speak to the chief of police who wasn't there. Ended up getting into a fight with two different officers, and Officer Morgan comes out of the back room with Blue, and these 2 officer and a defendant are on the ground wrestling, and there's Blue standing there wagging his tail. But that's not even the best part of the story. It was actually it was on October 31st. It was Halloween, and Officer Morgan, who does community outreach, was dressed as Officer Barbie. So she was in a completely pink police officer uniform. But I will say that her presence de-escalated the situation. The defendant immediately responded to her in a very calm way. So great job in what you do, and thank you for what you do, officer. I appreciate that. I was talking to Officer Blue. No, no, but I do thank you. I see you on Facebook all the time and what you do in the community. So thank you very much. And you were very impressive with that video, how you were able to calm that defendant down. So sometimes that's all it takes is just your presence. So you guys ready to get started? Mr. Patterson.
My daughter.
Okay. And did you encounter the defendant that evening around 11 p.m. when he came out to the parking lot to discuss you're still moving in?
Yes.
Okay. So just so that I'm clear, we're talking not about the June 14th, but prior to when your mom was moving in?
Correct.
Okay, go ahead. And at the time, did you claim that you needed to finish in order to return that truck the night of your mother moving in?
Did I make that claim to you?
To Mr. Heed, the defendant, not to
Yes.
confuse you. Okay. I'll refer to my brother as the defendant just to make sure that we don't have any confusion here. Did you know your move-in date when you were moving your mother in?
No, I didn't.
Okay. Between the time you moved your mother in and the time you moved in, did you discuss the time of day that you would be moving in? Do you recall the events of June 14th relatively clearly?
Yes.
Okay. You had stated that the defendant said ass grabbing. Are you sure he didn't say grab ass?
From what I recall, he said that's right.
And on the 14th, did you remove the goods in that truck from another location? In other words, you were moving from someplace to 4840. Did you both load and unload that truck on the same day?
Yes.
Okay. What time did you start?
I don't recall the precise time I started to move the truck.
Okay. And when you had talked to the police that evening, you had stated that that was your last load.
Correct.
Is that correct? So do you recall who was carrying goods from the truck up to your apartment in the last load?
The very last load, I don't know who all had something in their hands. So I don't know.
Okay. And you had testified, I believe, that you never opened your door fully, correct?
Correct.
How did you and the other people with you get the goods that you were carrying into your apartment if you never opened the door fully?
We came through the door. We didn't have to push the door all the way open to its maximum ability for everybody to enter the unit.
So what was being carried?
Again, I don't recall, but all of the big things were already in the apartment at that time. We were bringing in the last of the stuff off the truck.
How do you open the door to that apartment? Is it a key or a card?
It's a fob.
Okay. And who had the fob? And the door was locked when you got there?
When I got there, I don't remember if I had to swipe the fob to get in or if it was already open due to the fact that we were coming back and forth with the truck. I don't recall on that particular trip if we had locked the door before we went back downstairs.
And you had mentioned that you have a soft close door. At the end of the soft close, does it soft close right to the end, or the last several inches, does it slam?
It slams at the end.
Wouldn't that hurt somebody's foot if that door slammed right at the end, if they stuck it in?
Not necessarily.
When you were moving in on 614, you were aware that the building that you were in wanted everybody to be relatively quiet. And in fact, you signed a form that said quiet enjoyment, didn't you?
I didn't sign that.
I'm going to object. There was a cop-out question.
Fair enough. I can separate the question out.
Go ahead.
So did you, prior to moving in, sign a form concerning quiet enjoyment of your unit?
Yes, I did.
And so when you moved in, you were aware that that community observed quiet enjoyment?
I was aware that they observed quiet enjoyment as a resident of the property that did not pertain to moving in.
Does it say anywhere on that form that it doesn't pertain to moving in?
It is not.
So where did you learn that it doesn't pertain to moving in?
You can't move into a property quietly. There's going to be noise when you do that.
What noise in particular did the defendant complain about?
That he heard us in the hallway.
Were you laughing and carrying on?
We were talking.
Were you laughing and carrying on in the hallway?
We were talking.
Did you say to the police, or your mother say to the police in your presence, that you guys? Fair enough.
Go ahead.
Strike that. I'm going to ask this a different way. Isn't it true that you told the police nobody could tell you, nobody could dictate when you move in?
Yes, I did.
And did you also tell the police that no one can tell you how much noise to make when you're moving in?
I said no one can gauge how loud it's going to be when you move in. I didn't make that statement, yes.
Nothing further.
Any redirect? The conversation about trying to get hired by community corrections. Did that happen? When in that evening did that happen?
That happened after the fact, once I kind of called and explained to them what's going on.
So the police had talked to you
Yes,
and they went inside, right?
they went inside to talk to him.
Okay. And they came out and at least had told you that they had talked to him.
Yes.
All right. And then it was sort of in casual conversation afterwards that came up. Okay. Nothing further.
Ma'am, what were if you recall, what were the last things you were carrying into the apartment?
I don't recall.
But it wasn't like you had said, correct me if I'm wrong, that the large things were already in.
Correct.
So one could assume you weren't like carrying mattresses or couches or anything at that point.
No.
Right. Okay. And you're not sure as to what time this is. Did you receive a complaint or communication from the apartment complex regarding moving in?
No, I didn't.
Any noise or anything? The ass grabbing or grabbing ass, whichever, was that comment directed at you? Well, let me ask it a different way. Did you have an impression as to who that was directed at?
The impression that I had was that he was speaking to all of us.
What did that mean to you? That terminology, that phrase.
That you guys are playing around in the hallway and almost kind of like we were children playing in the hallway, just being loud.
Okay. Any questions based on the court's questions? From either side.
I do have one.
Actually, a couple. At the time that this incident happened, did you think you were being too loud?
No, I don't.
Okay. How loud, if you recall, about how loud were you talking?
It was just an average conversation.
Any louder than we've all been talking today?
No, I don't know.
Thank you.
And Bree, sit down. When you were moving the last items in, as you're moving in, I'm presuming, and I may be wrong, all the four of you weren't all coming in at the same time, were you?
No, we were. We all got off the elevator and we all were heading to the apartment.
Was that true for the whole move?
No.
Okay, so at certain points, and again, correct me if I'm wrong, at certain points, there might be others, two or one of you that would go down, come up, and then
Correct. We were
going back and forth. So not all four of you were together always.
Right.
Okay. Before this incident you described, though, you're indicating to the court that all four of you were coming in at that point?
Yes, it was the last trip from the truck at that point. We were wrapping up.
Okay, gotcha. This prior occasion that you that you and the defendant came into contact, I guess when your mother was moving in.
Mhm.
Was there anything eventful about that encounter?
Yes, it was actually, he approached the truck, we didn't, obviously we did not know who he was. He was like, you guys are being very loud. Why would you decide to move in at this time? And at that time I expressed to him, you can't control when people move in. You should be aware that you're moving into a building that's brand new, so people are gonna move in. And there's no time restriction on that.
Okay, and this was 2 or 3 weeks prior to the
Correct.
14th. What time was it that move-in was occurring?
That was later in the day. This was probably, it was dark outside. I can't remember an exact time, but it was later in the day, like late at night.
Okay. That day, that previous day, was there only one encounter between you and Mr. Yee?
What do you mean, the day my mother was moving in?
The day your mother was moving
There was one encounter with him. Yes.
in? Okay. And it was as you described that he came out to your truck.
Correct.
Okay.
He also made a statement about, us letting the building door slam. He said, you guys are right under, my unit with the door, but if you're moving things in, you can't really control the door. You're not holding the door and holding on to things at the same time.
Well, okay. So then on the 14th, was the same thing happening where the door was slamming?
I'm not gonna say that it didn't slam at all, because again, we did have big things that were on that truck. It required us, as we were going in, to use both of our hands. So if the door were to kind of close hard behind us, we didn't have control of that every time.
Okay. But at least on the first occasion, there was complaint about the noise and also the door slamming and his proximity, or at least what he relayed to you, his proximity to where the door is.
Yes, and then he made a statement about us needing to pick a better time of day to move in, as if he had control.
Well, but let me just ask this. You indicated that on the 14th, you moved in at 9 PM.
It was a little bit before that.
Okay, but it was around 9.
But we were there around that time.
Well, you, in questioning from the prosecutor, you said you were moving in about 9 PM.
We didn't start at that time, is what I'm saying. We're already there. So we had been moving in for a minute at that time.
Okay, fair enough. On the weeks prior, you had indicated that it was a later time that you moved in.
Yeah,
So
we
it
got
was-
a later start.
So it was sometime after 9?
No, we were there after 9 o'clock. We got there a bit later that particular day, but which kind of had us stay there longer. So the 14th, when I moved in, I pulled up with the truck maybe 4 or 5 o'clock in the afternoon, something like that, when we initially started. But on the weeks prior, when me and my mother was moving in her stuff with my daughter and her friend, that was a bit later in the day when we initially arrived. So maybe like 7-ish or something. So we were still there.
Okay, so maybe I have a misimpression and I just want to clear it up.
Mhm.
prosecutor indicated, or your response to the prosecutor in regard to a question was that this is occurring at 9.
The incident with the defendant,
Yeah,
yes,
okay. So you had been moving in since on the 14th, I'm talking about, since about 5 o'clock?
yeah, 5 or 6, something like that.
Okay, so this is 4 hours thereabouts that you're moving things in.
3, 4 hours, and yes.
Okay. You arrive, when you're moving your mother in,
Mhm.
you arrive a little bit later. Does it take that same amount of time?
I can't recall how long it took us that day exactly, but I do know it ran later into the night than when I moved in on the 14th.
Gotcha. Okay, fair enough. So during the previous incident, at what time did the defendant come down to the truck?
Again, I don't recall the exact time. I just know that it was later in the day. It was already like nighttime. It was dark outside and kind of later in the evening.
When he came down to the truck?
Correct.
So maybe we'll do it this way. When he came down to the truck on that occasion,
Mhm.
were you at the end of the move or?
I can't recall how much stuff was left on the truck. I just know we were still in the process of getting things off.
Let me ask it this way. If you had to, I don't want you necessarily guessing, but if you can approximate, were you halfway through the move? Were you 3/4 of the way? And I'm talking about the previous occasion.
With my mom.
Yeah.
And her things. Say maybe about a quarter of the way. I had to try to
So
regulate.
you were about 1/4 of the way done when he came down to the.
Correct.
All right. Any questions based upon the court's questions?
No, Your Honor.
I have a couple that might help. I hope help. When you moved your mom in and on the 14th, did you think you were making any unreasonable noise moving in? Was it sort of the standard noise from moving in that you would expect into an apartment complex?
Yes.
All right. Now, were you trying to make a bunch of noise when you moved in?
No.
Were you trying to be aware of the other residents?
Yeah.
Okay. Thank you.
All right. And we may step down. Thank you. Call your next witness.
People rest. Oh, I'm sorry. No, I do want to call Officer Rakowski.
All right. So please come forward and be sworn.
For you take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so.
Thank you.
Go and have a seat. State your first and last name for the record, please.
Colton Rakowski, COLTON,
All right, you may inquire.
Thank you. You work for Pittsfield Township Police Department?
Yes, sir.
And were you working on June 14th, 2025?
Yes, sir.
At about 9:08 PM, did you get dispatched out to 4800 Clark Road?
The call was originally dispatched to Officer Dana and Officer Strick. I jumped the call shortly after that bit system.
Okay. Was that about the time that the call came out, though?
Yes, sir.
All right. And when you arrived, had Ms. Hogan, to your knowledge, completed her move by that point?
To my knowledge, at that time, I'm not sure.
Okay. Thank you. Nothing further.
No, Your Honor.
All right. Thank you.
Now that people rest.
Witnesses for the defense.
The defense calls the defendant, Michael Heed.
All right, sir, please come forward and be sworn. Not actually be able to, just come on up. Like. Sir, before you have a seat, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, have a seat. Upon having a seat, please state and spell your name for the record.
It's Michael Joseph.
You may inquire. That's fine. We've got this stuff.
Okay. Mr. Heed, how old are you?
So,
Now, before we get too far along on this, I want to ask you, did anything occur a couple days before June 14th that was of note in your life?
I guess I had pretty major facial surgery.
Okay. And when you say pretty major facial surgery, what exactly did they do?
They trim my eyelids and raise my eyebrows. And there's a lot of stuff in the face.
So who did that surgery?
Dr. Simmons at Kellogg Eye.
Did they provide you with any information about what you could and could not do after the surgery?
Oh.
Just make it quick. No, I think this is going exactly, Your Honor. This shows that he could not have done some of the things that he was accused of that night.
That's the reason that you're offering this testimony.
Yes.
Judge, being told what you can and can't do has no bearing on what you do and do not do.
And certainly you're entitled to make that argument. Objections overruled, you may.
So, stated shortly, what did they tell you?
Yeah, with more than 5 pounds, you're not bent over. Sleep on your back so you don't abrade the stitches. Your clothes under you so it help with the swelling.
And so where were you sleeping after the surgery?
On my couch, it has rolled arms, like an extra pillow.
And as part of your preparation for this surgery, did anything in your unit provide you concern?
Yes, there's a pre-operation session and got a less detailed list of restrictions after the surgery, among them 5 pound limit on weight. So I was concerned that the apartment door, since it's heavily damped, would exert more than 5 pound pressure. So I measured it. It was indeed, in excess of 20 pounds.
Okay. And so I want to take you now to the first time you encountered Erica Hogan. Do you recall approximately what time you went out to the parking lot?
I said after 10. She said on the stand 11. I'm willing to accept that. It was dark.
Fully dark. Okay. And what did you say at that time?
I said, so kind of late.
After talking with them, did you think that they were going to stop immediately or they were going to continue?
I got the feeling that they were going to continue till the job was done.
Did they in fact continue until the job was done that evening? Okay. So I want to turn your attention now to the night of the 14th. Where were you in your apartment when you made the decision to talk to the Hogans?
Flopping between the couch and the recliner. I'm a bit tired of laying in one position. I would switch to the other place and try that for a while.
And what caused you to get up?
Well, it was 9 o'clock. You showed that, it was the sky was starting to darken a little bit. My body was telling me that, it was in a space where it could, get some serious sleep rather than just cat napping. So I was trying to get some serious sleep.
And did you hear anything that made you get up?
I heard the Hogans and company, both downstairs and upstairs. They're both in very close proximity to my apartment.
How far is the elevator from your apartment?
About 15 feet.
And did they arrive up at the elevator before you got up or after you got up?
Oh,
And when you left your unit, what did you do? Did you, well, strike that. Did you have shoes on? Did you put shoes on before you left your unit? When you left your unit, did you see the Hogans?
I did not. I could hear them.
When did you first see anybody in the Hogan party?
Well, there's a curve in the hallway at the elevator, so once I got past the elevator, I could see them.
As you approached unit 313, did you catch up with any member of the Hogan moving party before you got to 313? When you got to apartment 313, was the door open? How close were you to the last person going into the apartment?
Maybe 5 seconds behind.
How far is it from that elevator to the Hogan's door, to the door of 313?
50, 60 feet.
When you got to the door of 313, it was open. Who did you see inside?
Yes. You said it was open?
Yes.
Okay.
Who did you see inside the apartment?
So Erica, she was holding the door. Angela was in the laundry room, which is off to the left of the entry. And
Did you see anybody else?
the 2 young people were further in the apartment, kitchen, living room area.
Could you see them?
I don't believe so right away.
And what was your purpose in going to apartment 313?
To tell them I was badly in need of sleep and that they were making more noise than I felt was necessary. And the management wants to emphasize people's right to quiet enjoyment and like a courtesy visit of complaining to the management about what you're doing.
What happened when you started talking?
Everybody else started yelling.
Did you use the words ass grabbing when you started talking to them?
I believe it was grab ass.
What does grab assing mean?
It's from the Army. My drill sergeant alive. It means horseplay, goofing around. Anything that's not directly pertaining to your assigned task.
And did they have any reaction when you use that word?
Maybe not. They definitely got agitated and misunderstanding that might be a part of it.
How long did the whole encounter with Erica Hogan last?
I would guess 15 seconds.
Did you ever intentionally enter her unit?
I did not.
Did you ever touch her?
I did not.
Did you ever touch her door?
I did not.
Did you put your foot in the door to stop it from closing?
I did not.
Would you put your bare foot in one of those doors to stop it? Why not?
I mean, they survived the incident.
Okay.
Too close to call.
Your Honor, I would like to show the witness and the court the door that is to the witness's apartment to show the closing mechanism.
There you go. All right. You should be good.
All right. So
There it is.
there we go. All right. So let me back this up to start. So.
Defendant's K is being admitted.
This is a demonstrative video just so that I can answer additional questions. We can't omit Exhibit K also. So if you turn to your book, Exhibit K.
Any objection to the admission of Exhibit K? All right, Exhibit K, the video is admitted as well as the picture of the door. Go ahead, Counsel.
So you had earlier indicated that you had concern about your own door and its weight.
You need to, correct? You need to. I don't know what's, okay, go ahead.
Yes, thank you. Just to make sure we don't inadvertently project anything else. You had indicated that you had concerns about the weight of your own door. Given your concerns, were you in a mood on June 14th to push past anybody?
No, in fact, it was the impression given to me by the surgeon that my face could, in a sense, fall apart if I overexerted myself.
Okay. You recall approximately how many sentences you tried to say to Erica Hogan?
About 3. Too much noise management concern and making a formal complaint.
Okay. And when you say management concern, has management told you as part of the residents at 4840 that everybody needs to be quiet?
Yeah, there were just a couple at that point. That was like 3 weeks after I moved in. Group emails that said, reminding you that there's, quiet enjoyment policy.
When you approached Erica Hogan on the night of June 14th, what was your expectation of what was going to occur?
Well, I was hoping just to deliver the message and go back and try to be a little more quiet.
And since you have been at 4840, have other people moved in?
Yes.
Has anybody moved in later than the Hogans moved into Angela Hogan's apartment?
Angela was definitely.
Did anybody else move in as late as Erica Hogan? Did you complain to anybody else about the noise they were making moving in? In your own assessment, were the Hogans louder than other people when they were moving in?
Yes.
Nothing further.
Cross-examination.
Thank you. You didn't have any trouble opening your door that on the 14th around 9 p.m.?
Um,
Well, let me, okay. And you opened it to go talk to Angela, or excuse me, Erica. You also opened it when the officers knocked on your door?
on my crack, yes.
Well, you opened it enough so that your entire body was between the door frame and the door?
Yeah.
Okay. And you didn't, when the officers asked you for identification, you went back into your apartment to get it, you didn't ask them to hold the door for you because of your eye surgery, did you?
I did not.
You told the officer that you'd put your foot inside of Erica's door?
I did.
You didn't say that? Okay. You told the officer that you didn't get into her apartment more than a foot? Is that correct?
The statement I remember is I may have put a foot in the apartment. And at that point, you know, immediately after the incident, I wasn't sure.
So you didn't say that you didn't get into her apartment more than a foot?
Unqualified, I would not say that, no. Because I had no intention of harming.
Did you tell the officer or not that you did not get into her apartment more than a foot?
Again, my recollection is that I told him that I may have.
Your exact words were that you got your foot, you stepped inside the apartment, but it was inadvertent. Do you recall making that statement? Do you believe the same rules apply to you as they do to Erica Hogan? So she should be able to enjoy the quiet enjoyment of her apartment?
Yes.
And not have people hold her door open? You said you saw people in
Just so
the,
that we're clear, because this apartment complex has the legal definition of what quiet enjoyment really means misconstrued.
I think we could probably stipulate that within the lease, Judge, with court's information, they redefine quiet
I know,
enjoyment.
I understand that, Mr. Tivolowski. I just want to make sure that the record's clear.
Oh, thank you.
That we're not talking about legal quiet enjoyment, that we're talking about what the apartment complex has called quiet enjoyment.
Yes, we will stipulate to the fact that it's not the legal definition, Your Honor.
Thank you.
I actually got out blacks last night to look at, to make sure I was thinking correctly. Thank you, Judge. You told the so we saw the video of the door closed. How is it that Erica's door didn't close behind her like in the video? Well, let me back up and I'll ask you a different question. You said that you saw some people inside the apartment. Okay. And you had followed Erica over to her apartment.
Mhm.
And that's a yes. And
She was not the last. Her daughter and her daughter's boyfriend were the last two in line, so they were, I guess, essentially the ones that was following.
but you passed them and actually caught up to Erica.
Never passed anyone.
Okay.
We're all in the compartment.
All right. You told the officers that the person you were talking to, was that Erica?
Yes.
Okay. You told them that she turned her back to you. Is that correct? Does that signify that she doesn't want to talk to you at that point?
I think it was, my impression was it was to get out of the way of the door so they could close it.
Okay.
At least in part.
Now, and you told them that when she turned her back to you, you still wanted to tell them that they were being too loud.
Yeah, I wanted to finish my statement, and the noise created by the 4 people in the apartment yelling at the same time made it difficult for her to hear.
So Erica was past her door, letting it close by this point?
She was still in front of him. Yeah, she turned and was, going to get out from in front of it.
Earlier on your direct examination, when you were asked if you had touched Erica's door, you shrugged your shoulders. Do you recall doing that? Okay. Do you recall for sure whether or not you touched her door? We don't want you to guess.
Her door may have touched me, as far as sticking my foot in the door, that did not.
Okay.
Thank you. I don't have any further questions.
Sir, just so that I'm clear, your intent on going down was to tell them that they were being too loud.
Right, that I, stood a realistic chance of actually getting some sleep for the first time in a couple of days.
And the prior occasion, what was your intent on approaching them at the truck?
Well, that was much later. That was, she said 11. I just said after 10. And that's the generally accepted definition of quiet time. My understanding is between 10 at night and 8 in the morning. So,
okay, well, so my question was, when you went down to the truck on the prior occasion, what was your intent? Just to tell them that it was too loud?
yeah, tell them it's after 10.
Okay. It's been indicated that you said that in questioning from the officers that you may have inadvertently stepped into the apartment.
Yeah, that sounds accurate.
Okay. When you left your apartment and were going down the hallway, did you have any intention on going into her apartment?
No.
You get to the door, and at some point while you're at the door, you don't know whether or not you crossed the threshold. Is that correct?
I was trying to stay close to her ear because there was a lot of ambient noise that I had to talk around.
Okay. So she's at the doorway, right? At the time that you get to the doorway.
Yes.
How far from, if you recall, from the threshold was she while you're at the door?
She was like at the handle end of the door with the door like fully open. And she was holding onto the door.
So when you approached the door was fully open.
Yes.
And so you're standing there talking. All right. When you say she's at the handle end of the door, was her body to what would become the outside of the door or the inside of the door? If you know what I mean by that.
Kind of both. She was at the end, with her front like bent around on the side and her, back maybe behind the door.
Okay, so, and you've by your description and by what you were doing, what I took from that is her body is actually behind the door.
Part of it.
Part of her body is behind the door. Is the door closing at that point, or she's just behind the, part of her is behind the door? And is her face facing out?
Yes.
Okay. And at that point, you're talking to?
Yes.
To your understanding, at that point that you're saying anything, is she trying to close the door?
No, I didn't get the impression anyone was trying to do anything other than make a lot of ways and scare me away.
Okay, when you say that, was somebody saying something to you?
Well, they were all yelling, get out, go away, but whatever.
Okay. At some point you leave and the door closed and you walk back to your apartment. Is that correct?
That's correct.
So would it be correct in saying that once you arrived at the door, it was anything but quiet necessarily?
Well, as soon as I opened my mouth to say make too much noise, then everyone lit up immediately, almost immediately.
Got it. Okay. All right. Any questions based on the court question?
I don't have nothing further, Your Honor.
I do have one other question. The previous occasion, did you report that to management?
I don't believe I did.
Okay. This occasion, did you report it to management?
I did not, because by the time the next day rolled around and management was in a position to receive the message, things kind of snowballed. So we were on a different path at that point.
Gotcha. Sir, if you thought there was too much noise, is there a reason why you didn't call the police?
Well, two reasons. I moved to this apartment complex from Evergreen, which is also in Pittsfield Township, and I called them with noise complaints a couple of times. And they told me not our problem, that should be taken up with management. And also the management sent out a group email that said, don't call the police about noise complaints, take it to management.
Got it. Okay. All right. Fair enough. Any questions?
Nothing. No.
All right. You may sit down. Thank you, sir. Any additional witnesses for the defense?
Your Honor, the defense rests.
All right. Any rebuttal witnesses for the people?
1 second, Judge. Just recall Officer Rakowski very quickly.
All right. Sir, please come up. I remind you that you're still under oath.
Sure. Thank you. Were you there when officers were talking with the defendant?
Yes, Officer Dana and I went to speak with them here.
Okay. And do you recall when the defendant was asked how far he made it into the apartment?
He stated that he inadvertently had stepped into the apartment.
Okay. Did he say how far or how much?
Not that I recall, but it was, I don't recall, it's something to do with the what he made it inadvertently stepping foot into the apartment.
Okay. And did you recall if he made any gestures to demonstrate what he did? Okay. Were you wearing any body camera that day?
Yes.
If I show you that body camera, would that help to refresh your memory?
Yes.
Okay. May I approach the witness, Judge?
Yeah. Do you know what he's gonna show?
Oh, sorry, it's his body.
Yeah, no, we've seen all the body camera footage.
All right.
Sorry, thank you. Okay, did seeing that help to refresh your memory?
Yes.
Okay. And did the defendant make any gestures demonstrating what he did with his foot?
He did make a motion, a stepping motion, stepping.
Okay.
Doorway.
Okay, like across the threshold. All right, thank you. That's all.
Was that in proximity when he said he may have inadvertently stepped in?
Yes, that was during when we were talking about.
All right.
Nothing further, Your Honor.
All right, you may step down. Thank you, sir. Any additional witnesses for the people?
No.
Closing argument.
Your Honor, I believe that we've established beyond a reasonable doubt that the defendant did enter without breaking apartment 313 at the apartment complex
What
4800.
would be the requisite intent the people would need to show regarding this offense?
Judge, I think it's not a specific intent crime. I think it's more
I understand
generalizing
it's not a
crime.
specific intent crime, but
A generalized intent to do the act, and the fact that he admitted to completing the act and Erica testified.
general intent to do what act?
To cross the threshold. If I may, Judge, the jury instruction in a home invasion case, which is very similar to this, the jury instruction for entering without permission, there's case law that says any entrance, however slight, is sufficient.
I understand.
So I think
that's not what I'm asking.
Okay. So I would say, I believe, and I would suggest to you that the intent to cross the threshold, which in this case allowed the defendant to get his statement in, to get his admonition of the Hogans into them because he wanted to
But if
tell
it's
them.
an inadvertent, you would agree that that would not be the requisite intent necessary, general or otherwise.
If it's an accident, that is, I would say that's likely a defense. And I
Well,
think
then give me your definition of inadvertent.
I think inadvertent and accident are probably co-equal in this situation.
Okay.
However, the fact that the door didn't close, and we saw how the door would close if no one's in the way, tells us that there was an intent to prevent the door from being closed, which means he meant to cross the threshold. And then, as Erica described, he put his arm sort of around the door because he wanted to tell them what he wanted to tell them, which was, I'm upset with you. Effectively, I'm mad at you. I'm upset with you and you're making too much noise. Knock it off.
Or I went to sleep.
Yep. So that's the argument, Judge.
All right. Thank you. Closing.
Keep this very brief, Your Honor. First, the defendant believes that the court identified the key issue here, which is the intent. This would be a general intent to cross the threshold. I believe his testimony is that if he did enter the apartment, it was inadvertent. He did not have the intent required to cross the threshold. I also think that the two parties are telling very different stories about the same event, and that often happens in cases like this. But I would point out some of the inconsistencies in Ms. Hogan's recitation. She first said that the defendant kind of wrestled past her and entered her apartment. And then she said that when the door was almost completely closed, he stuck his foot in. It just, as she was reciting it, none of that made sense when you saw the video of how the door closes, that he could push past her and somehow, have her come around him and everything. I mean, that recitation is a much larger, almost altercation. We believe what the evidence shows is that, the defendant had encountered Ms. Hogan previously. They had been moving in, well after 10 o'clock, as late as 11 o'clock, and continuing on after 11 o'clock at night. He had a very real concern that they were going to do the same thing on the night of the 14th. He went down expecting nothing more than he had previously had with them on the prior occasion. There was no intent to do anything. He wasn't in a condition to have the kind of combativeness that Ms. Hogan described. And so the defendant would ask that the court find him not guilty.
Anything else?
I think you can see the defendant's intent when he admitted that she turned her back to him, yet he wanted to make sure that they effectively got a piece of his mind. He crossed the threshold of someone else's apartment. He wouldn't leave when they clearly said, go away. I think that's why I found guilty.
All right, let's stand in brief recess. I'll come back to my decision. All right. Please.
Sure. Your name? WEST. What is your position with the company? Okay, this is a criminal case. If it was a civil infraction, I could bend the rule. I can't bend the rule. You appeared without an attorney, and I can't allow a corporation to appear without an attorney. I'm not trying to make lawyers money. I'm going to adjourn the arraignment and pretrial. You have to hire a lawyer, okay?
This is the only paper I have. I don't even know why I'm here. I don't know what.
You're here because of a violation of ordinances, no registration, no registration, it says, no permits. So you should talk to a lawyer. I just can't let you represent a corporation. That's essentially me and requiring you to engage in the practice of law, and I can't do that.
Well, I don't know what, I don't have.
I don't write these rules.
No.
Did they give you the ticket?
I don't have the ticket though.
You got it at one point, though.
This is all I had. This was sent to my home.
Hang on. Put the paper down.
Yes.
Did you ever receive the ticket?
I never received the ticket.
Heather, make them a copy of the ticket. You're charged with a misdemeanor, not you, your company is.
Can I pay the ticket? What's the ticket?
Listen.
Your Honor, it's all respect.
Hang on. Your name's John West, right?
Robert.
Robert West.
Yes.
That's fine. I can't let a person represent a corporation. The only people I can let represent corporations on criminal cases are lawyers. I can't let you appear for the corporation. You're going to have to hire a lawyer. We will give you the ticket. And you can take a copy of it, call your lawyer. It's a building code violation. And it gets more involved. Okay? So we will give you a copy of the ticket down the hall. We will give you a new court date right now, and you'll get your notice down the hall. And then you call your lawyer. Are we doing this 2 weeks from today?
Quick question. Yes, Judge. February 11th at 9:45.
February 11th at night. I'm sorry.
And I'll need that file down here to give him a copy of the ticket because it looks like it's a handwritten ticket.
No problem. So she's going to give you a copy of the handwritten ticket. Call your lawyer, talk to your lawyer.
I got a question. It's a ticket for minor that you said.
It's a building code violation. It's a criminal charge.
Okay.
Listen to me. I want you to listen because I'm going to answer your question.
Yep.
I can't let you represent the corporation.
I understand.
What's your question?
The question is, did I pay the ticket and be done?
No, it's not just it's not just a civil infraction. It's a criminal case.
I'm so confused. I was paying the things.
I didn't listen. All I do is sit here and know the law. Okay? I don't tell townships what to write. I don't tell city attorneys what to write, how to draft ordinances. But they wrote the corporation. The corporation must own the property. If they don't, then you tell your lawyer that. Your lawyer can come in and say they issued this to the wrong party. I don't have anything to do with what they do. Nothing. Zero. They don't consult with me before they decide to charge. I can't let you pay that. It's not just a ticket. It's a ticket, but it's a criminal charge. It's a misdemeanor.
What's the charge?
It's a building code violation. Resident hired National Electric for flickering light. I'm just reading off the bottom. It's handwritten, so I'm going to do my best. And informed resident he needed new electrical panel. They replaced panel. Still having issues. They still didn't register or get a permit, it looks like. Okay?
Okay. That's a quick for permit.
Sir?
Pay a ticket. I don't understand why I'm.
Listen. How many times I got to tell you?
What do you tell them?
You gotta have a lawyer. I've told you that 5 times.
Okay.
How many more times can I tell you? This is not my rule. I don't write the rules. I just know what they are. I've known them for years. I'm not treating you different. I don't know what else to tell you.
I just asked a question.
You need a lawyer. I don't know how many times I got to tell you that to make you understand it. It's not my rule. If I let you do this, I got to call the state bar. You know why? Because if you're trying to represent the corporation, you're engaging in the unauthorized practice of law, just like I would be engaging in the unauthorized practice of medicine if I set up a shop next door and started fixing arms. You get what I'm saying?
I get what you're saying.
Okay. It's not my rule. I tried to tell you nicely. Don't make me raise my voice with you again.
Think about you raising your voice.
Go ahead and go down the hall. Good luck.
Great day.
You too. You'll get your notice and you'll get your ticket.
See you in 2 weeks, sir.
Okay.
Thank you.
Yeah, let's put a sign to things.
How you doing?
Good morning, Judge. Good. How are you?
Would prefer to be back in Naples right now. Everything's good. Everything's good. Just don't know why our society's be so argumentative, Mr. Dillon. I really don't get. Everybody thinks they've got it the right to argue. They don't, they're lawyers now. Priority Waste LLC, 26B 1500193. Your appearance?
Still on behalf of Priority Waste, P5648.
All right, so you're pleading the overweight, agreed upon fines and costs of $2,000, right?
Yeah.
So that charge on behalf of the company, which you're authorized to enter into, correct?
Yes, ma'am.
Responsible or not responsible?
Responsible.
Plea is accepted. Fines cost $2,000. I'll give you until February 27th. Or are they having real issues?
A little extra time with me.
What, can I ask you a question?
Yeah.
Why are they doing all this? I mean, it's got to be killing them.
Well,
I mean, you're in here all the time. I feel bad for them, but they're not complying with laws. Their life would be a lot easier. My God, this has to negate any and all profit that they.
I agree, Your Honor. And it's, part of the problem is use of lift axles that many times we're not, we're pulled over without them bearing weight, which increases the overweight of our axles, and that's the driver issue. The other is just the crunch of business and having to get all the tread picked up and logistics and timing wise and taking it to the dump. So, I mean, this court isn't the only one that we have these issues in it.
I'm sure. What did I give you until on the other one? March 14th?
Yeah.
All right, on this, I now have 25B1497608 and B. Your appearance again?
Alex Dillon, B5264 on behalf of the person.
So the misdemeanor B file is going to be dismissed. You're going to plead responsible to the A file, and you're authorized there in that plea to overweight. True?
True.
To the charge of overweight, responsible or not responsible?
Responsible.
Please accepted. Fines costs of $2,800 paid by March 14th. I'm going to go ahead and dismiss the B file. People Against Priority Waste LLC, 25B15010A and B. Your name?
Morning, Your Honor. Alex Dillon, G52648 on behalf of Priority Waste.
We have a misdemeanor here, file B, that will be dismissed as part of the plea agreement. And then we have another overweight agreed upon fines and costs of $2,000. True?
Correct.
To that charge of overweight, responsible or not responsible?
Responsible.
Plea is accepted. Fines costs of $2,800. Pay by March the 14th of 28. Where are these guys based out of again? Clinton Township?
Yeah, that's where the corporate office is.
Are you in house with them or? Oh, no, wait, this wasn't 2,800. This was 2,000. My apologies. Right? This is 25E150100.
Yeah, 2000.
Yeah, I said 2,000. Heather, my apologies. It's 2,000, not 2,800. And 25B15010A, file B is dismissed. Fines costs on A 2,000 paid by March the 28th.
These trucks come out of a yard in Rockland.
Prior, is there something up, Mr. West, now?
I was waiting for the bail. I don't know where to go.
You go right down the end of the hall to the judicial clerks, all the way down to the window. He's going to bring the file down in a second, okay? Priority Waste LLC, 25B1500019A and B. All right, appearance again.
Good morning, Your Honor. Alex Dillon on behalf of the Priority Waste. I borrowed on 52648.
So what year did that put you out?
I graduated in 94.
Out of law school?
Yeah.
So you've been at it, what, about 28 years?
Yeah.
Goes fast, doesn't it? This is my 43rd, and I'm wondering, it seems like about 14 as a judge, 32nd here, and it's.
Yeah, I saw your photo out in the hallway in 1995, and it's when you started. It's when
I was walking down the probation department one day about 3 years ago. Right, probation's right across the hall, and the guy says to me, "Judge," he's waiting out there. He says, "Is that you?" I said, "Yeah." He says, "Why don't you get an updated picture?" I said, "Why in the world would I do?"
You don't look like Shipley now.
Oh, give me a break.
That's what he should have said.
I don't. Anyway, I don't know if I took this one. So you're agreeing to pay on 50019A fines costs of $1,800, dismissing the P file to that charge, overweight, responsible or not responsible. Please accept it. Fines costs of $1,800 due by March the 14th, or do they need a little more time?
No, that's over, March 4th.
And then I'm dismissing the B file, the misdemeanor. Have a great day.
Thanks.
Nice to see you always. I'm gonna run this one down. I'll be right back. Stay seated, sir. We'll be right back with you, okay?
What happened, Lee?
Sadie, when I do a bond sheet, I'm gonna try to give the bond sheet to you to give to them.
Okay.
What's your last name? What person? Hey, Woolley, bring your stuff up.
She's not answering.
He's what?
She's not answering.
Duffy, Richard Scott Duffy, 26B149972, A and B. Mr. Duffy, good morning. Your name? All right. So you got a good license. He's moving to dismiss the driving on a suspended. You have a valid one, I should say now. He's dismissing the no proof of insurance, or she is, I'm sorry. And you are going to be responsible to the civil infraction of distracted driving instead of the no proof. True?
Sure.
All right. You have insurance, right?
Yes.
Okay. To the charge of distracted driving, good morning. To the charge of distracted driving, that's a 0-pointer, responsible or not responsible?
Responsible.
All right. $175 on that. Please accept it. No proofs dismissed. The suspense dismissed. You can go down the home, pay that, and you're all set.
Gotcha. Thank you
Have a good day.
You too.
You have a hearing in front of me? Counsel? Yeah. Or are you just trying to learn something? I'm just kidding.
I believe we have a early discharge for probation.
Okay. Did you bring the file
Give me
in?
1 minute. I gotta get this down.
We'll get him out of here. How's things going?
Did you drink there?
Not in this weather, you're not. All right. Pfeiffer?
Yes.
Wesley Harold Pfeiffer, 253-665. Okay, so the only thing I'm gonna ask on these when they're early discharged, your name, sir?
Wesley H. Pfeiffer, sir.
Can you write up, you're moving to dismiss then too, right? Yeah, this was taken under section 771.1, I believe. Yeah, and I said a prosecutorial review date for March 25th. So they're entitled to early discharge, but as far as I'm concerned, when you enter into an agreement with them on one of these statutes, you still have to move to dismiss if you have no problem with that. I wouldn't think you would.
No objection, Your Honor.
Can you just, so you're gonna move to dismiss on this?
Yes, Your Honor.
All right, can you write up a stip for me real quick? Just saying defendant compliant, case dismissed. Mr. Pfeiffer, your name again, I'm sorry.
Wesley.
Would you mind doing that now if you would?
Yes.
Thank you. We're not gonna have any more problems over there, are we, Mr. Pfeiffer?
Sir, I hope not, but there's been problems since I've been in there. Not with me, but with the neighbor. After the,
You guys live on West River Road.
after the removal.
Hang on, West River and what?
Between Ferry and Riverview Park.
Beautiful area.
It's beautiful, right across from the park. It's lovely. Love it. Been there 35 years.
You know how many people give their left arm to live on West River Road?
I had wonderful neighbors for many, many years.
And now you guys are fighting over there? I'm not putting the blame on anybody, any else. It just seems like crazy to me.
It is, sir, and, like I started to say, I mean, I got pictures of the, but I'm not gonna bore you with them.
No, I'm not, listen, I'm not casting aspersions. It takes two to tango as far as I'm concerned on these neighbor disputes. Oh, wait a minute. Do I know you?
I was part of this construction, I can build it.
I know, but I'm reading something here. Did you read this letter from this victim here?
Yeah.
Here, you read the letter that the victim sent, right?
Yes, sir. I'm checking, this is dated when?
January 26th. I'm gonna read it to you. I'm gonna read it to everybody. My name is Michael Yutchuk, and I received in the mail notice of a Wesley Pfeiffer probation hearing on January 28, 26. Heather, I want you to do me a favor, because I get tired of this. I want you to call up this phone number for Mr. Yutchuk and ask him to zoom in.
Okay,
It's
Judge.
it's 734
Mm-hmm.
658 0168. Have I
Okay, I'll
ever
call him
met
right now.
you?
Just, here's. Nova Social.
I want to read this letter.
Step right in.
I have so many friends out there that I don't even know of. You know that?
Oh, yeah, absolutely, sir.
No, I know. I just want you to know that this is the kind of nonsense. First, I thought probation was an alternative to being sentenced formally. You know what? A clear reading of the statute, I can't say I disagree. But courts have been handling them this way since I was a lawyer in 1983, the 771 statute. It's a delayed sentencing statute. And what it essentially means is somebody's on probation, then they're sentenced. But that's not the way courts have handled this for decades. On probation, a convicted individual would be allowed not to be formally sentenced if they were able to show good behavior, provide restitution, and complete the probation period lawfully. I am appalled that Mr. Pfeiffer, a repeat offender with trespassing, would be allowed to have his probation discharged early. Now, I don't know if he had a prior that was from 2000. He said, as I previously stated, Wesley Pfeiffer has been convicted once before on 12 August 19 for trespassing with his neighbor to the south. Is that true?
Yes, it is, sir.
Not only that incident, hang on. Not only that incident, but I'm sure you have access to the 33rd District site where Wesley Pfeiffer has multiple cases and convictions with the 33rd District Court. He's had a blatant disregard for the law concerning both of his neighbors to the north and south. If you go back further, he was involved with his neighbor to the east, Mateo Argusa. He has a clear and established history of disregarding of the law and respecting others. Third, yourself and the court are going to do whatever you desire with this case anyway, ma'am. He's writing the probation. Wesley Pfeiffer and Judge McNally have a personal relationship outside of the court, so I'm not surprised he's being handled with kid gloves. But please relate to Wesley Pfeiffer. I'm not contacting Grosio Police, the courts, or anyone else concerning his unlawful behavior anymore. The courts and Grosio Police have proven that his behavior is acceptable, and constant slaps on the hand have not changed his behavior. In closing, after I assume the court's discharge his probation, if he trespasses, destroys my property, threatening my children, I will assume he's intending harming them or someone I love. We'll take it from there. I want this gentleman on Zoom.
Judge, I've tried calling him 3 times. He's not answering.
I'm going to call him right here myself. How's that?
Okay.
I hope you don't have to be anywhere because I want to get this gentleman on Zoom. I don't like people making accusations about my integrity. One thing I can honestly tell you, I don't play favorites. Never have, never will. Didn't in 1995. I'm not today, and I won't as long as I'm sitting on this bench. Hang on. Give me my Zoom ID again. 448-415-2913, is it?
Yes, Judge, that's correct.
Chief Duck, I'm not available to take your call right now, but if you leave it, 2931, I need your call. I'll return your call as soon as I possibly can. Thank you very much. Have a good day.
At the tone, please record your message. When you've finished recording, you may hang up. Press 1 for more options. To leave a callback number, press 5.
Mr. Miachuk, this is Judge McNally from the 33rd District Court. I'm on the bench. I've got Mr. Pfeiffer in front of me. I'd really like you to log on. I'm going to make him wait. I want you to log on. It's the Zoom ID is 448-415-2931. I'd appreciate it if you'd log on as soon as possible. I want to hear from you. Thank you. All right. So I'm going to ask you to have a seat. You've moved up to dismiss, and I want to know how I know you. That's what I'm going to ask him, among other things. I get so tired.
Can I get any information on that?
I don't want to talk about it. I'm going to wait for Mr. Yachuk. He thinks that we're friends and go out socially, apparently, or golf together, or whatever else they think. And I want to clarify some things before I dismiss this. That's what I'm doing.
Thank you, sir.
So you wrote your skip up, right?
Okay, I paused, Your Honor. I know you wanted to.
Okay, well, that's fine. If you want to take a different position, you feel free. I mean, I'm just telling you, I didn't notice this. If I don't notice this at all, so until I pulled the file up, so you don't have to do anything. But I do want this gentleman to appear. I'm waiting till at least 10:45 for him. I'm sorry, Mr. Pfeiffer. Abdullah Mohammed Hawatman. Hawatme, I'm sorry, 25B149772A and B. Good morning, Ms. Payne. How are you?
Good to see everyone. Sharon Payne, P 38749.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson is live.
You may be seated. We're back on the record in the case of the People versus Speed. In this case, there are renditions of what occurred that day. A couple of things are of note to the court regarding what actually leads up to the purported illegal entry. And that is that this court observed as Mr. Heed was coming up to the podium, and granted, he may have been walking different than he would have back in June, but the court finds it hard to believe that he got himself into the hallway and then past 4 individuals in that hallway to get to that door. And the court's having a very difficult time believing that occurred. I believe what Ms. Hogan says is that all 4 of them were coming in at the same time with the last load. That makes sense. But that part of the scenario also doesn't fit with what is agreed, at least between Mr. Hogan or Ms. Hogan and Mr. Heed, that the other 3 individuals were in the apartment at the time. So trying to reconcile some of the factual development, that is the conclusion that the court came to. The issue really is, and it is a general intent crime, is what was Mr. Heed attempting to do? Mr. Heed was attempting, right or wrong, to let him know that he needed to sleep. I'm not sure that that is entirely Ms. Hogan's responsibility. The notion of when she moves, when she doesn't move, that is in a lot of ways irrelevant for the court for these purposes, because it's not a noise complaint charge. That's not what this is. When one gets to the issue of illegal entry and when one examines some of the case law regarding illegal entry, what is clear, and I think conceded by the people, is that an inadvertent or accidental entry would not constitute a crime. There would have to be some indication that the defendant's intent was to indeed enter those premises. If his intent was to make known his displeasure, that still doesn't mean that he illegally entered. The only evidence that's really before the court is that his entry into the premises may have been a step into the premises or his foot on the door. And in certain instances, that can constitute an illegal entry. In this case, however, I believe what the defendant is saying in testifying, and that is when he told the officers that he inadvertently stepped in. Inadvertently doesn't cut it for the purposes of intent to enter the premises. Quite frankly, both parties probably could have found a better way to handle this entire situation and not bring it forth this way, but it's here. It is the people's burden to show beyond a reasonable doubt that the defendant illegally entered the premises. He has to have the intent to enter the premises. It can't just be something where it is inadvertent or accidental or something along those lines. The proofs in this case, and from this court's viewing of the proofs and listening very closely to the witnesses, I can't get beyond that any entry from this gentleman who was barefoot at the time into that apartment or on that threshold was anything but inadvertent. I think his intent was to say what he wanted to say about the noise. That was it. He wasn't intending to go into that apartment. He wasn't intending to step into it. Had the door remained open and he could have just said it that way, I think that's exactly what he would have done. So for those reasons, and it being the people's burden to show beyond a reasonable doubt that the defendant committed this offense, the court will find that the people have not sustained their burden in that respect and would find that the defendant is not guilty of this charge.
Thank you.
All right, thank you.
Mr. Hawatma, how are you? Your name and your name. How you doing? Thanks for coming. Raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation in these proceedings between the court and the defendant and his lawyer and anybody else if I call in the prosecutor or whatnot.
I do.
All right. I have, first of all, counsel. And again, you speak Arabic.
Correct.
And he does not speak fluent English, correct, Ms. Payne?
That's correct.
All right. So for purposes of arraignment, does your client stand mute and waive formal reading? I have an A file, which is, I have a B file, which is leave the scene of a property damage accident. I have an A file, which is operating while intoxicated.
Your Honor, we've had an opportunity to pre-try this matter. The city has offered a reduced charge of operating while visibly impaired and failure to stop at a property. My client has been advised of his rights relative to a trial in both matters. And he has indicated he wishes to accept a plea offer from the city.
Is that what you want to do, sir? Okay, so wait for him to interpret, okay? If you plead guilty to operating while visibly impaired and guilty to failure to report a property damage accident, the prosecutor will move to dismiss, and I will dismiss the operating while intoxicated and to leave the scene of a property damage accident. If you plead guilty to operating while impaired, the possible penalties are as follows. Up to $300 in fines, 93 days jail, 360 hours community service, court costs, or all of those. 4 points will be added to your traffic record. Your license will be suspended or revoked in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand all of that?
I do.
If you plead guilty to failure to report, the possible penalties on that are up to $100 in fines, 90 days jail, costs, or all of those. No points would be assessed on your traffic record as a result of that plea and conviction. You understand that?
Yes.
And if you plead guilty to those charges, I do want you to understand, I'm going to go ahead and dismiss the operating while intoxicated and the leave the scene 6-point violation. Do you understand that?
Yes, sir.
Did the interpreter read to you? Hang on one second. Did the interpreter read to you the advice of rights form?
Yes.
If you plead guilty, you're going to be giving up all those rights, and we will not have a trial of any kind. Do you understand that?
Yes.
Any questions before we go on?
No.
To the charge of operating while visibly impaired, how do you wish to plead?
Guilty.
To the charge of failure to report a property damage accident, how do you wish to plead?
Guilty.
Were you operating a motor vehicle on October 16 of 25 at 10:08 p.m. on Telegraph near West in Brownstown Township?
Yes.
Prior to that, did you drink alcohol, and if so, what and how much? Several what? How many is several?
4 or 5.
Was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way?
Concentration.
Were you involved in an accident?
Yes.
What happened that caused the accident?
Can I let you, my client here?
Yeah, go ahead.
On October 16, 2025, you were driving your truck, correct? And you came to an intersection, correct? In the city of Bounce. And you were turning left. And you turned left in the path of an ongoing car, correct?
Yes, I did.
And did that occur, that accident, at least in part because of your alcohol consumption, do you feel?
Yes.
And after the accident, did you leave the scene of the accident without calling the police and remaining on the scene?
Yes.
Are you on probation or parole? Anybody force you to plead guilty or promise you anything to induce you to plead guilty other than a dismissal of the operating while intoxicated and leave the scene?
No.
And again, to the charge failure to report a property damage accident, I'm sure I asked you that, but I want to ask you again, how do you plead, guilty or not guilty?
Yes.
All right, I'm gonna accept your plea to failure to report, accept your plea to operating while impaired. They've been made voluntarily and understandingly and are accurate. The OWI is dismissed. The leave the scene is dismissed. I'm going to refer you as required by law for a screening and assessment. You're going to be screened and assessed today. You're going to be sentenced at a later time. All right. So I'm going to refer him for a screening and assessment. He's got a prior in 2011, true, out of Ohio. $1,500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. And by the way, counsel, you stipulate that the blood result was accurate, 0.131.
Correct, we would stipulate that.
I'll accept the plea to operating while impaired, accept the plea to failure to report, dismiss the OWI, dismiss the leave the scene, refer you for a screening and assessment, $1,500 personal bond, no alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You have to attend AANA at least once a week. He was never fingerprinted in this case. He has to go over also as a condition of his bond to the Brownstown Police Department by 1 p.m. today to be fingerprinted and photographed. I'm going to give you a sentence date. You'll go down the hall. They're going to fax over the order to Brownstown. I'm sorry, I'm going too fast. My apologies. I'm going to give him an order for prints. They're going to give him one down the hall. Actually, they're going to fax it over to Brownstown or email it. He's going to go down, get his court date, which I'll make sure is good with you now. Then he'll go over to probation. He will fill out a questionnaire and be interviewed. He has to go to AANA at least one time per week. That has to be in person. And again, he has to go over to Brownstown by 1 p.m. today. Okay? No, we're going to give it to you now and make sure it's good with you. What date do you have for me, Heather?
February 11th at 8:45.
February the 11th at 8:45. Is that all right or not? Okay, what you want to do, what do I have the following week, Heather?
17th is good.
I have to do it on when Brownstown's here because there could be a claim for restitution.
It would
What?
be, we have February 25th next. We could do we're pretty open. So if at what time works for her?
I'll do 9:30 for you, right? You can't do the 26th,
25th,
26th or 5th?
5th, 2/5.
5.
Not do 2/5.
Oh, boy. Okay. Do I have another Brownstown docket day in February?
Oh, you know what, Judge? I'm sorry. We do, we have the 19th.
How about the night? Okay, so we'll do the 19th and that'll be at 9:30. Okay, that's what you wanted, right? So February 19th at 9:30. And they'll give you all the paperwork down the hall. I am gonna hand you, counsel, the bond sheet right now. For your client. And you can get the court date down the hall. Okay?
I think you're on.
Have a great day. And make sure he goes across the hall to probation. And we'll have to get the interpreter again, Heather, okay?
Yes, Judge.
Thank you. Have a great day. Good luck.
Thank you.
Carlton Thomas Johnson, 25B149959. Good morning. Your name? So you're charged with driving while unlicensed. That's a misdemeanor, and you have the right to a lawyer. If you want one, I'll give you one. Would you like a lawyer? All right, we'll set you up. I will go ahead and give you a lawyer. You go out in the hallway. It's going to be a while, okay? So just be patient with them, all right? They're very busy out there. And you go out. And you will be represented by Mr. Gay or Mr. I don't know. I don't know who's doing what anymore. Is that yours?
Yes.
Okay, so you'll be represented by Mr. Gaith. Okay? All right, we're all set. Do you have a case in here ready for me to go?
I guess we're ready to
Tell me which ones.
Ms. Brown, Mr. Kenny, and Mr. Stump.
Bryant Allen Kinney, 25B148464.
Good morning, Judge. And I have to on behalf of Mr. Kenny.
Mr. Kinney, your name?
Bryant Allen Kenny, the order.
All right, so we're gonna adjourn this to, we need an adjournment for a couple weeks, Heather.
We could do the 11th at 9:45.
The 11th at 9:45, Mr. Gaith, okay?
That works.
All right, that's what I'm gonna do. You go down the hall, get your notice, and you're all set.
Thank you, Judge.
Counsel, you don't have to stay in here on this other case. When he calls in, I'm gonna get you. Unless you got nothing else.
No, we have a couple of measures.
Okay, thank you. Amy Diane Brown, 25B149845 A and B and C.
Good morning, Judge. And I have to get on behalf of Ms. Brown. Prosecutor Queen.
Me, Diane Brown.
And we're asking for an adjournment on this matter as well. Ms. Brown has a couple of issues to respond to the Secretary of State. So we're asking for 30 days.
Okay, ma'am, you gotta move on this though, okay? This could be your last adjournment, all right? Give me 4 weeks out, Heather,
That'll be February 25th. We could do 8:45.
at 8:45, okay? So I'm gonna give you that date, February the 25th at 8:45. And you are going to go down the hall and you are going to get your notice.
Yeah.
And that's how we'll handle it. And you tell them when you come in, and I'm gonna call you first, okay? I don't want you guys waiting on the court appointed. You have Pfeiffer, no, you
I
don't.
have Mr. Stump.
Stump, Jacob, Timothy Stump, 25F11627.
Good morning, we get their back to implement. Jacob, come to do some. Ms. Wiles is the probation.
Okay, she's not in. Is he gonna have a hearing or what are we gonna do
He's
here?
gonna plead judge guilty to all 3 counts.
I think we are really backed up. We only have one probation officer in there. I don't want to drag her in. I'll take the plea and I'll schedule it for sentencing. Fair enough?
Never.
Fair enough?
Yeah, that's fine.
Unless it's gonna really create problems, but
I did, what do you mean by schedule it for, like, are you scheduling another court date? Is that what you're saying?
let me take your plea first and then we'll talk. So your lawyer tells me that you're going to plead guilty to all 3 counts. Is that true? If you do that, I want you to understand you could get 15 days in jail. Do you understand that? Did you sign an advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and we are not going to have a trial or a hearing of any kind. Do you understand that? As the count 1 that you failed to attend your scheduled probation visit on January 9 of 26, how do you plead?
Good.
As the count 2 that you failed to attend anger management with 4-week follow-up, how do you plead? Is the count 3 that you failed to provide proof of completing 8 hours of community service by October 31 of 25, how do you plead? Did you fail to complete your community service by October 31 of 25?
Yes.
Did you fail to attend and complete an anger management program?
Yes.
Did you fail to attend your scheduled probation visit on January 9 of 26?
Yes.
Anybody in the world force you to plead guilty? Pleas are accepted to all 3 counts. He's not taking this very seriously, huh?
Well, Judge, he's already made up the anger management, he's finished that, and he's also completed the community service.
When did he complete that?
The community service, I believe, was completed on January 2nd.
Oh,
The paper.
it was supposed to be done, I thought. Didn't I tell you October 31?
I didn't read the paper. I'm sorry. I want to apologize for that, and that's my mistake. I'm a very busy person. It's my mind.
What are you doing for a living?
I'm part owner of my dad's company. It's called Simpson Lawn Services. I'm not employed by anybody. I just completed my own job. I charge $6,000 for that. I do drywall. I'm a carpenter.
All right, slow down. Slow down. Let me talk.
But he owns his own company. He helps manage his father's company. He graduated high school from Woodhaven, Judge. So he's steadily employed.
Mr. Stop.
He's been responsible.
I sent you September 4th.
That's right.
I told you to do anger management. Let
That's
me
right.
finish. I told you to have a community service by October 31. Unless you're fighting in a war and didn't tell me, or you're working for the Pentagon, you're not too busy. I'm sorry.
You're right.
Okay? So let's get past that. Has he started the anger management?
He's finished. It's completely.
All right.
Reason I had missed one day of the. Yes, sir.
You do your court work program?
Yes, all of us. On my.
You provide all this proof to Ms. Wilds?
No, I have the paperwork in my hand for my community service. This is the paperwork that I
Is it on stationery?
It's good,
Yes, it's on Goodwill Station.
Goodwill.
And did you provide her with proof that you've done the anger management?
They said that they were sending over the paperwork from the building that I do it online. I was actually planning on also doing more just because I help benefit me.
But he did not provide this document, these lots, but he doesn't have it with him. He's due for review on the 26th.
Of February, right? All right, I don't think I need, the more I think about it, I won't need Ms. Wilds. He's gonna return. Is there anything else anybody'd like to say before I sentence?
Unless Mr. I just want to say I'm sorry, and I do take your court very serious, and I do.
It's not my court.
You know, the probation, I took it, I do take it serious, and I have respect for you guys. I wasn't intentionally trying this, like I said, and I truly am sorry. I am trying. It's been the hardest 6 months of my life, bro. But I'm on my own. I don't have much. Like my mom, you know, my mom and dad, they've been here before. They don't help much, so I'm doing everything on my own. I work on my own.
How old are you?
I'm 20. I'm 20 years old. Yeah.
You mean you're referring to them coming in front of me, right?
Yes, they've been.
I mean, you're not accusing me too, like somebody else just did, of knowing somebody and.
No, absolutely not. No, I would never do.
I mean, you know.
No, I'm saying you know them.
Talk about agitating, huh?
No, I did see that. That'd be pretty irritating. But no, like my parents said, my mom has a reputation.
All right. I'm not taking that again. I'm not holding that against you. Pay additional cost of 75. You're to serve 8 hours additional community service by February 16 of 26. And we will go from there.
Yeah, I can say that to them. Appreciate it.
You're gonna pay the $75. You're gonna get your community service done. You're to provide proof of completion of anger management.
Yeah.
That's also part of the order. You understand that?
Yes, sir. Do I have to call them up and get like printed paperwork?
You can go over to probation and ask them if they've received anything. If they haven't, then yes, you're gonna have to do that.
Okay, that sounds good.
So you're gonna go over, John, he'll tell you where to go. You're gonna go talk to the probation secretary and you're gonna ask her if they've received proof that you completed anger management. If they haven't, you have to do it immediately, okay? You're all set. Good luck.
Thank you.
Carlton Johnson, is he here? Okay.
Yeah, just let probation across them.
Oh, boy. June.
I had a conference for House's file.
I thought I just put it down. I've got it right here.
Well, I've got enough. Well, I've got one that's
I'm so
probation.
sorry.
Is it two?
I love
Yeah, the
this.
warrant.
That's a lot.
Oh, okay.
What's that?
A lot needed drunk driving with the
Wow.
interpreter. This is the other file that needs to stay with it.
Oh.
Did you want to do that show with the warrant, Judge? Is that?
No, you're fine. Go take care of what you need to take care of.
Oh,
Well, he has a warrant.
No.
He has a warrant.
Oh, yeah. Mr. Gaith?
amazing.
You need that.
For you. Back on record on Wesley Pfeiffer. You stay right there. 25I-253-665.
Judge, I just tried calling Mr. Uchek about 2 minutes ago again. He did not answer.
Hi, this is Mike Uchuk. I'm not available to take your call right now, but if you leave your name, your number, and the time that you call, please call us at the weekend. Thank you very much. Have a good day.
At the tone, please record your message. When you finish recording, you may hang up or press 1 for more options. To leave a callback number, press 5.
Mr. Uchuk, this is Judge McNally. I'm still waiting for you. I've got Mr. Pfeiffer here. I want you to have every single opportunity to lodge every objection that you have. So we're going to wait for a little bit. And I have a couple of questions for you before I decide how I'm going to proceed. Show causes, most of them. It's on. Your name?
Wesley H. Pfeiffer, sir.
Your
Morning,
name?
ma'am.
Good morning to you. Your name?
Wesley H. Pfeiffer.
I've called twice. I've had my judicial clerk call at least once or twice. The probation officer even tried to email them. It's unfortunate that I won't have the opportunity to address what I consider to be defamatory, libelous statements made by this victim. It sounds like he's making threats, but it's always easy to be gutless on social media or in places where you don't show up. What is your position?
Your Honor, so Matthew Wayne on behalf of the Township of Grosse-Ile. Good morning. The township's position has not changed, owing to the fact that per the agreement that the township struck with the defendant, and as his probation officer indicated that he's taken all steps and abided by all the terms and conditions of his probation, the township stipulates to dismiss the charge.
Before I go on and do this, I want to make sure. I've never met you. I'm sorry?
No, sir. I'm sorry.
I mean, you look familiar, but you know, I've lived in the community here since I was 1. I mean, my parents moved here from Dearborn when I was 1, and that was in 1959. So I see people, I meet people. I got so many friends that they say that they're my friends. Oh, I'm friends with Judge McNally. I might have met someone who met them at one point. It's just disheartening because an attack on my integrity is nothing I'm going to take lightly at all. It's too bad he didn't have the guts to call back. Case dismissed. Motion to the prosecutor. Hand me your form. Well, wait a minute. I got to swear you in first. Raise your right hand. You solemnly swear to affirm under the penalties of perjury, the testimony you've given these proceedings will be the whole true self you got. Since October 8 of 25, have you been arrested for any reason? No. Any new charges? Any contact with the police? You moved to dismiss?
Yes, Your Honor.
You have the form filled out?
Do Your Honor? Signature from me.
And for the record, it was under 771.1. You can hand that right to my recorder. That's why when early discharge, if just for the record, as long as accusations are being hurled, prosecutors will typically go ahead and adjourn these when half the time period's up. So that's all I'll say about it. I'm going to figure out what I'm going to do going forward. Case dismissed. Good luck. Thank you. Are you ready on all those?
I'm ready, except Mr. Myers. Thought I told him to come into here, and I don't see him in the building. Then we can ask John for you.
Where's John at? Do you know? You seen John?
We can do the first two, Judge.
Let's do them. Teresa Lativia Hurst, 25B149-712A and B.
Good morning, Judge. My name is Nick Fairbathens first, the search city for Please go to the.
Before we go on, I need to inquire, is Cheyenne Wheatley here, Heather?
No, Judge.
All right. Just give me 1 second here, please. So the plea agreement provided that the defendant plead guilty with agreed upon probationary term, I believe, of 12 months under section 771.1 to file A, assault, and she also pled responsible to careless driving, file B,
Correct.
with the reckless driving as set forth in file B to be dismissed. I referred her for a pre-sentence report. The victim has failed to appear. Restitution, if any, is to be handled through civil litigation. Have you had the opportunity to review the report with your client, and are there any material additions, corrections, or deletions?
We have had a chance to review the report, Judge. Factually, it's accurate for the most part. I have one issue though with the recommendation. You did say 12 months. We agreed upon, it recommended 6 months.
Well, I know, but the plea agreement's entered into with the prosecutor at 12. I'm not sure. They don't really look at that. Sometimes they recommend more or less. I generally go along with what everybody agreed upon, and I can't say I see it differently in this case based on what I've read. So I'm going to stick with the 12 months.
Other than that, Judge, no, we have no mission.
Ma'am, is there anything you would like to say?
Yes, sir.
Okay.
I have learned from this, and next time it's gonna make better choices, or not next time. I've learned from this, and I've say that I should have just walked away from the situation.
Well, I'm glad to hear that because it doesn't sound like you're acting like a choir girl out there. I mean, you're threatening to kill somebody. There's an independent witness that says you were threatening. And children, why is everyone so angry anymore? Is what I ask myself every day I leave here. Why are people so angry? If it's that bad, I don't know what to tell them. I don't know what to tell them.
On Ms. Hurst's behalf,
I know, but go ahead.
She has no prior criminal history, Judge, other than this incident. She's been steadily employed as a customer service supervisor with Detroit Metro Airport for the last 20 years. She has a 17-year-old daughter that lives with her, Judge. She is a sole caregiver and financial support for the household. Obviously, she's 41 years old, so I mean, she's gotten to this point, Judge, with no criminal history, no prior convictions. Obviously, I'm on her behalf. I would say she's doing something right. Obviously, everybody needs its control. Sometimes maybe says things they don't mean. I believe this was the case. I don't know that it doesn't, based on what I know from Ms. Hurst, she wasn't going to act out on any of those threats. It was just made out of anger and frustration. I would have to take that into consideration.
At least you're showing some contrition. I read this report, and I don't know mind telling you, I was pretty intent on doing a lot worse than I am going to do. You don't threaten kids to kill kids. You don't threaten to kill people. You were driving too fast. in a zone where there were children around and the woman yelled, and I don't know what somebody would expect them to do. If I saw my grandkids, somebody speeding down my street, I would undoubtedly say something to them. That being said, I'm going to fine you $235 on the careless on the assault case. Prosecutor agreed for it to be taken under 771.1. Here are your conditions. 12 months probation. You cannot leave the state without the consent of the court or violate any law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with the victim, Cheyenne, weekly, or her family members. No firearms, no dangerous weapons. You're not to possess those. Restitution, if any, will be handled through civil litigation. Again, anger management with 8-week follow-up. I can't wrap my head around this one quite. 2 days court work program, 2 days of community service. Your community service, 16 hours, has to be completed by April 1. We'll put you on the court work program for 2 days. There's a $35 a day charge for that. Fines 100, cost 200, 75 victims' rights fee, $50 justice assessment. So fines and costs are 4.25. Probation fees are $240 for 665. Screening fee is $60 for 725. Court work program fees of $70 for 795. Attorney fees are $40, $835 is your total. You pay that, you stay out of trouble. I'm going to give you a review hearing date. You may be eligible for early discharge, but you have to, again, ask the prosecutor then to dismiss after 6 months. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that, ma'am? Okay, so what do you have in terms of a date for me, review hearing date, Heather?
That will be January 27th.
January 27 of 27 at 8:30 in the morning. You have fines and costs here of $835. Can you take care of all that now? How much do you have today? How much did you come with today? You should have come with some money today. You're making $1,500 to $1,800 a week, right? Right?
Yes. I'm in a bankruptcy program, so not really.
Are you in bankruptcy now?
Yes, sir.
Do you have proof of that? All right, here's what I'm going to do. Probation to set up terms of payment. No payments to be made. So you can't even make payments to be made until, and it's an obligation of you to notify the court defendant is out of bankruptcy until you've completed bankruptcy. Okay. So we don't want any of your money until your bankruptcy is over. Then you have to notify probation, and then they'll set you up on a payment program. Okay. Do what you're supposed to do, Ms. Hurst. You seem like a nice lady. And then you have 235 on the other one, same thing. I'm going to say, so just remember, this is a little different. We don't have this happen a lot. But make sure you put that all over. Payments not to be made. And I'm talking to you, Heather, on the computer until after bankruptcy completed.
Okay, Judge.
And that's on both files. Okay. You'll meet with probation before you leave. I hope that this was just an isolated incident. I have every reason to believe your lawyer. Best of luck to you, ma'am. Myers, you'll meet with probation. David Elwood Myers, 25B149844.
Good morning, Judge. Madison Gate, appearing on behalf of Mr. Myers.
We're going to need a jury trial on this.
Mr. Myers, take a moment.
All right, so we're going to set for a jury. Caitlin, I need you in here, please, on this Myers. We're going to set a final pretrial in 2 weeks, Heather. So we can do that on February the what is it, the 11th or 12th?
Sorry, Judge, I was muted. That's February 11th at 9:45.
And now we need a jury trial date. Your appearance? I'm gone the 4th through the 12th. what day are we going to do this?
Have it scheduled with you on March 20th.
Is that gonna go? Well, let's set this one for March the 20th. Let's set this for March the 20th at 8:30, okay? Again, you guys, I'm gonna rely on you to get me the jury instructions due by March 15th, okay? And I know you do a good job. I think you did the last ones, didn't you? And you put them all together for me, and I really appreciate that. So that's what we're gonna do, sir. Do you have questions for me? Okay, I wish you well. Go down the hall. You'll get your dates. You're gonna be back here in 2 weeks and then on that date in March. Thank you. Johnson. Thank you. Charlton Johnson, Carlton Thomas Johnson, 25W838-349. He's not getting much time from me. Your name?
Good morning, Judge. I can get the back and switch down.
Did he just walk in today? Did you just walk in today?
No, I was set at 8:45 this morning, but
Hang on. Hang on. Did you post a bond? Is that what happened? How'd you get a court date? I'd issued a warrant for his arrest.
He
Back in
had
July.
two separate cases, Judge. So he was scheduled, let me find him on here.
I believe the warrant was issued on the, Woodhaven case.
Was issued on this one too, and we recalled the warrant. Listen, don't play with me anymore, okay? You were supposed to be, I arraigned you on April 30th, 25. Yeah, we still doing playing around with this case. Last adjournment on this one. Put it all over the computer. If somehow, some way I'm not here, I anticipate that happening. We're setting a trial.
Judge, because Mr. Johnson would like to go through the Clean Slate program to try to get this issue resolved, can we get at least 30 days on this last?
I'm gonna give it to him in 2 weeks, and I'm setting a jury trial date. Give me, he didn't show up. I adjourned this 2-3 times, and he just decided he was gonna play hero and not show up with us. We doing this on the 11th again?
Yes, Judge, will be at 10 o'clock.
10 o'clock. That's the last adjournment, and now we're gonna set a jury trial date, unless he wants a bench trial. It's up to you.
Do we make?
I'm gonna set it now. The clock's been running on this thing. He hasn't been here.
Pretty much touch next, so you need to make sure. You want bench trial? Very.
What do you mean? Slow down.
Judge, he just got custody of his 2 minor children, and he just also lost his job. I think what the issue is mainly is financial.
Well,
in this situation.
I mean, why'd he stop showing up for 8 months? No, don't give me that life stuff. I don't want to hear.
A lot of excuses, but seeing that who you are, I just tell you life, man. I'm here today.
It's not, you just can't do this, okay? You know, you show a little respect, it goes a long way. You can't fail to show up. I don't care if he wants a jury or a bench. I'm not looking to lock you up here, Mr. Johnson. That's not the point. The point is the Supreme Court wants me to do cases quickly. The point is you got warrants out for your arrest. I don't care if you want a jury or a bench. It doesn't matter to me, but I got to move the case. I'm not trying to be mean, but I got people that tell me what to do. Nobody thinks we have rules to follow, and we do. So I don't care. You guys want to talk about jury or bench? Are you sure? You have the constitutional right to a jury trial. I'll tell you what I'm going to do. You have the constitutional right to a jury trial. If you go with a jury trial, 6 people are going to be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. If you go with a bench trial, I'll be the one who will solely decide your guilt or innocence. Do you understand that? Still wish to give up your right to a jury trial? Anybody force you to do that? I'll accept the waiver. We'll set it for bench. I don't think the prosecutor will object. I'm not going to bother to call her in. I'm going to give you 4 weeks. I will do that for him, but then I've got to set it for 2 weeks after that. So Heather, I need a bench trial date in 6, and I need a final pretrial
4.
in 4.
All right, so the
Thank you.
final pretrial will be the 25th at 9 o'clock.
Okay.
And then let me see what our next date. March 11th, you are off. That's our 6 weeks out.
Do I have a Brownstown docket the week after that?
We do on the March 19th, we do.
Let's do it that day.
Okay, let me,
March 19th at,
you want to do 11 o'clock?
perfect. March 19th at 11, okay? All right, go take care of your business. Trust me, I'm gonna be fair with you. I just don't appreciate people doing this, that's all. What about this other one? I got another file here. Is this mine or Judge Simpson's? It's mine. Okay, so I'm entering a not guilty. We're going to bench trial on that one. On the other case, we have 25B149959. He stands mute, waits formal reading.
Yes.
Not guilty, please entered. Pretrial will be February. I'm sorry, I already closed up that file. What's the next date you gave me?
This one's a Woodhaven case, correct?
Oh, it is. No,
Yeah.
this is Brownstown too.
No, both, one is Woodhaven.
Oh, wait a minute. The Woodhaven case is the one that I just called. So I didn't need Brownstown. Let's slow down. My mistake. Can I still do February 25th as a final pretrial on a Woodhaven docket day?
That's Judge Hudson's Woodhaven days. We could do
So I can't do that.
No, we have Woodhaven.
That was my mistake. Let's take the Woodhaven case first where I'm setting the bench trial.
Okay,
I can give them 4 weeks or even three or 4 weeks. And then we'll set a bench trial on the first day I can.
so we could do February 18th for the pretrial.
Is that gonna be enough time? What's he gotta do?
He's gonna try to go through the state of Michigan's slate program.
He's not gonna get to it by then. You know what I mean?
He can't afford to hire a restitution lawyer, so I did advise him to go try to contact the state. Maybe they could help him resolve his issues.
Well, they might be able to, but they're not gonna, they gotta order prints and everything. I mean, they gotta go through the state police and I'll give you February 18th at 9 and then give me the bench trial date right after March the 12th.
After March 12th, that'll be March 18th.
18th at 11, okay? So you guys could maybe, yeah. Now
Judge,
that's
what
on
time did you give him
Woodhaven.
for, what time did
That's
you give
on-
him for the final pretrial?
I gave him still at 9 o'clock on February
Okay.
18th. Right?
Okay,
That's
perfect.
Woodhaven. That's all Woodhaven, right?
Yes.
And then on Brownstown, I'm gonna give him a personal bond. Let's see what happened here. Brownstown, I'm gonna give him a personal bond, $500. I'm entering a not guilty plea for him. And we'll set that one for pretrial. Can we set that on the same day so he doesn't have to come back twice?
Let me take a look. Sheesh, on the 18th, if we cross over, we can. Judge Hudson has Brownstown that day.
Let's do it at 8:30.
Okay.
8:30 in the morning on that day, okay? Thanks. Good luck. And make sure he's appointed Mr. Gaith on both of these, okay?
Okay, Judge.
Go down the hall, get your notices, and you're all set. I'll be fair with you. Don't sweat it. Just don't do that with me again, okay? Good luck. Do I have, what are you here on, Ms. Felder? Do you have I got a bunch of those clean slate cases back there. I didn't know one was up today. What's the name of the defendant?
Amar Alonsi, he's joined us by Zoom.
Okay, can you go grab that one, please? You can bring all of them. They're right on my desk. Amar Alonsi.
And Judge, I have an iPhone that's not responding to my chat, so I'm not sure who's on this
iPhone, you
iPhone.
need to respond. We don't know who you are. You need to put your name on there. Please start your video, state your name, and you tell us who you are. We can't identify you from just the words iPhone. We have no idea.
Destiny Triplet. I'm sorry, I don't know how to add
That's
it.
fine. Tell me your name.
Destiny Triplet?
Triplet?
Yes.
You got to start your video in the bottom left-hand corner of your screen.
Let me see.
They're
We do not have her on the dock
right on the
today,
desk
Judge.
pad.
Dusty, are you for time to pay?
I'm sorry?
Were you for a new payment plan?
Yes, yes.
Yeah, I believe I told you to zoom in during open court hours. No later than 10.
Literally 10. I'm sorry, I forgot the hours.
Yeah, you're gonna have to zoom back in tomorrow between open court, 8:30 to 10.
8:30 to 10. Okay, I'll come back at 8:30 tomorrow.
Okay, yeah, between 8:30 and 10. So if you could zoom back in tomorrow, okay?
Okay.
All right, thank you.
Okay, thank you. Bye-bye.
Bye-bye.
How do I? Oh, I leave.
Plots. That's not the real prosecutor has if I walk in right now. You gotta be able to. Yeah. Don't you, Michael Peterson?
I have a Casey Garside. Did you get a chance to look at this?
Yes, sure.
And I need the other ones in here. What case are you on, counsel, again, Ms. Felder?
Amar Alonsi.
I'll need that one and whatever. Is that yours? Hand that one up first, would you please?
Yeah.
All right, mine's Amar Ali Alonzi, 14B752588. All right. Your appearance, is he out there? I don't see him. Mr. Alonzi, you have to start your video, sir.
Good morning, Your Honor. Lakitria Felder, P86774 with Project Clean Slate, representing Mr. Amar Alonzi, who's joining us by Zoom and who consents to proceed by Zoom this morning. We're here on a
Yeah, your name, sir?
Amar Ali Alansi.
So he's just trying to get a expungement of a 2014 conviction for driving on a suspended, right?
Yes.
That's correct,
Counsel,
Your Honor.
what would you like to say?
Your Honor, Mr. Alonzi is eligible for this expungement. He doesn't have more than 3 felonies. He doesn't have any current pending criminal cases. The applicable time period has passed. And his post-conviction circumstances support this expungement. He is a high school graduate. He graduated in 2009 from Fordson Heights High School in Dearborn. He is employed currently in the restaurant industry. His primary task is caring for his disabled parents. He lives with them. His long-term goal is to get his record cleared, seek employment in the business industry, specifically transportation and delivery for a pharmaceutical company. It would be in the public welfare to expunge this, as it would allow him to go down that career path.
He didn't have a
earn more
commercial
money,
license at the time of this, right?
He did not have a commercial license, and he
So
was not
all
in a
I'm
commercial
checking, I want you
vehicle.
to look at the form here. I
Mhm.
get these infrequently and I want to make sure I don't make any mistakes. So I'm going to check box 3, applicants not been convicted of more than 3 felonies. Box 5, there are not criminal charges pending against him. 6, he's not been convicted of any criminal offense during the applicable time period pursuant to statute. Box 9, the time period required by statute for the conviction listed is passed. And An opportunity has been given to the AG's office and that's box 12, 13. Anything else I need to do? I
No,
cover
Your
all
Honor,
that.
that's it. I'll just add another caveat in the Attorney General's letter was that there is no traffic injury or death that resulted, and there was not. So he's fully qualified and meets all the criteria.
And all that's true, correct, sir?
Yes, sir.
I wish you well. Good luck to you. I'm going to go ahead and grant the application to set aside conviction pursuant to law. No objection?
No objection.
Thank you. I should have asked you first. My apologies. Do you have any more, Ms. Felder, or is that it?
That's it. Nothing further, Your Honor. Thank you.
Thank you very much. Mr. Skilleter, what do you have?
Mr. Lancey, you can log out.
Thank
Good
you.
morning, Your Honor. This is Patrick Gardner. I got Mr. Skilleter.
I'm sorry. He's dressed like a lawyer. He's dressed better than you are, Mr.
Come
Gunner.
on. That's true most days, Your Honor. You know
Let me call this Michael Peter Skilleter, 199-874-440. Your appearance?
that. Good morning, Your Honor. Patrick Gardner, P70106, appearing on behalf of Mr. Skilleter, who's present today via Zoom and dressed appropriately.
Sir, your name?
Michael Skilleter.
I did think he was a lawyer. I didn't think he'd been in front of me before. All right. So tell me about Mr. Skilleter. Is this a first drunk driving?
Yes, it was, Your Honor. It was the first alcohol-related offense.
The only one?
Pardon me?
The only one?
Yes.
Go ahead. Tell me what you want to say.
No, we filed the application to set aside the conviction. The statutory time frame has passed. The Attorney General's office has provided the documentation to the court with no objection to his request. He meets the requirements, and we'd ask that the application be set aside.
What is your client? Can I ask you a question? These things I get so infrequently. So I just want to make sure that I'm checking all the correct boxes. I got box 3. Has not been convicted of more than 3 felonies. True?
True.
There are not criminal charges pending against him. He's not, that's box 5. Box 6, he's not been convicted of any criminal offense during the applicable time period. Box 8, he's requesting a first violation. And again, all this is provided in law. The applicant's not been previously applied to or had a first violation OWI expunged. And then the opportunity was given to the AG's office. I just want to double check on this real quick here. Make sure that they responded. I don't see where the AG's office responded. Did you get a response?
Yeah, Your Honor, I have it dated January 15, 2026, addressed to the clerk of the court at the courthouse, where they say that it's consistent with the public welfare to grant Mr. Skilleter this privilege to set aside his conviction. I can scan it and send it to the clerk if you want, Your Honor.
Would you please? I'm going to need that. Send
Not
it
a
to
problem.
Heather. Heather, give him your email.
It's Heather at 33court.com.
Okay, give me 1 second, Your Honor. I'll send it now.
I appreciate that because I don't see it in here and I want to make sure all the paperwork's in order. So what are you doing now, Mr. Skilleter?
I sell steel, sir, for Kenwell Steel Company based in Dearborn, Michigan.
All right. And you haven't been in any other trouble since it's impaired 19?
That's correct, Your Honor. 0 trouble.
Good. I just need to get that that document from your lawyer because somehow, some way, I don't know why, it's not in our file here. I have the application. I have all the information from your lawyer. Heather, just confirm that you have it and make sure it gets in the file when you receive it. Will you please?
Okay, Judge, I'll let you know once I get it.
Just give me 1 second, Mr. Skilleter.
Not a problem, Your Honor.
What else do you want to say for Mr. Skilleter, Mr. Guntner?
Nothing, Your Honor. I heard you hear him a little bit. There's been no issue since the incident, and his application to set aside does meet all the requirements, and I respectfully ask it to be granted.
No problem. Heather, just confirm that you received it. I know
I just received it, Judge.
good enough. Application granted. I think I've got everything. I filled out 12. And the Attorney General's office, they're leaving it to the court's discretion. They didn't tell me there's any reason that they feel that I can't do this, right? Or do you want to send it down?
No, you're 110% correct, Your Honor. It says after the court holds a hearing and agrees that he meets the requirements, it's up to the court to grant it. However, they think it's consistent with the public welfare to grant the privilege.
All right, good enough. Application granted. Congratulations, Mr. Skilleter. I wish you well. Mr. Guntner, always a pleasure.
Thank you so much, sir.
You look fine. I don't.
Well, thank you. I'll take the backhanded compliment now. Thanks, Your Honor. I appreciate it.
See ya.
See ya.
Casey Lynn Garside, 05I 82878.